that I. 303.
I number?
I 303.
My lord, condonation of delay, my lord,
303.
3407 of 2023.
They have
No.
filed- they have filed an application for striking out the name of respondent
Which
number
one to be disposed of first?
for order 1 rule 10(2).
How?
No, my lord,
How?
that is
Say for they plead for striking out the
condonation petition
respondent.
the
So
court.
No, appeal is yet to be admitted.
that's it.
Delay is yet to be
Delay,
condoned.
delay may be condoned, my lord. The appeal may be admitted for hearing, my lord, and then, my lord, the lordship may take up all these
Do you
matters.
have any objection in condoning the delay?
We have filed objection also.
My lord, that objection I have gone through, my lord. This is, my lord, a routine-wise objection, my lord, that they have, my lord, raised, my lord. My lord, we have stated in our application, my lord, the reason as to why my lord, the delay occurred. My lord,
Why?
due
Why the delay occurred?
to co-petition
The delay has not filed, the lordship may be sufficient.
my lord, I have filed the medical certificate. Your lordship will find in the annexure, my lord.
In which paragraph of your petition you have explained it?
Petition the goal. Petition goal. My lord, at last page, my lord, your lordship will find, my lord, I have placed the OA, my lord.
Lordship,
My lord, your lordship will find due to psychic, my lord, Sciatica pain, my lord. He could
lordship
not
is
move.
applicable another
Just a minute, my friend. Just hold on. Let me conclude. My lord, either I may be allowed to submit, my lord, I may be allowed to speak, or he may conclude his part, my lord. This is not fair, my lord. I am
Yes.
submitting, my lord.
Sit down.
My lord,
Yes.
this is not fair, my lord.
Yes. In which paragraph you have explained it?
My lord, in paragraph number, my lord, I have filed a medical certificate, my lord. Delay petition, my lord, I have misplaced, my lord. It is there, my lord. In the last page, your lordship will find, my lord,
Yes, but in which paragraph you have
my
explained
lord,
it?
4 and 5, my lord. 4 and 5. Four and 5, your lordship, may I read, my lord? Thereafter, my lord, the opposite party plaintiff respondent file. Has your lordship got it, my lord? File title appeal number so and so before the learned district judge against the aforesaid judgment and decree dated 26/6/2020 passed by the learned trial court. The learned appellate court, after hearing the parties and on perusal of the evidence materials on record, set aside the judgment and decree dated so and so passed by the learned trial court as per the judgment and decree dated so and so. Then paragraph number 5, your lordship will find, my lord, that thereafter the engaged lawyer of the petitioner defendant appellant did not inform the petitioner defendant appellant regarding the aforesaid judgment and decree dated 14/3/2023 passed by the lower appellate court for about 3 months. However, on coming to know about the judgment and decree dated 14/3/2023 passed by the learned appellate court, Barpeta district, Assam, the petitioner defendant applied for certified copy on 6/7/2023, which was received by the petitioner defendant appellant on the same day, that is on 6/7/2023. It may be mentioned herein that the petitioner defendant appellant was suffering from sciatica pain my lord, sciatica pain for which he could not move around for about 4 months. That is from 6/3/6/2023 to 27/9/2023. As a result, he could not come to Guwahati to engage his counsel to prefer the second appeal before this honorable court against the judgment and decree dated 14/3/2023 passed by the learned Appellate Court, Borpeta District, Assam. The petitioner appellant defendant accordingly had to undergo medical treatment under supervision of Dr. Borpeta Civil Hospital, Kalgachia for a period as has been mentioned above. A medical certificate dated 27/9/2023 issued by the Superintendent Borpeta Civil Hospital, Kalgachia is annexed here to and marked as Annexure 1, page 13, my lord. Then, my lord, paragraph 6, we have stated, my lord, that the petitioner
Okay, okay.
my lord, my lord. That is the, my lord, inability,
Then-
my lord,
then-
which was beyond the control of the, my lord, appellant. my
Okay,
lord.
yeah, so what is your ground?
Lordship, going back to their affidavit in paragraph 5, they have cited they have a limitation period is more than 90 days. So Lordship, it can be counted to from if we count it from 6/7/23 to till filing of the appeal till 11/10/23, it will be 97 days, approximately around.
No, the resi has already counted it perhaps.
Lordship, also their reason seems not to be Lordship sufficient because they have, they could not contact the lawyer during that time. Also, their medical certificate did not cite any kind of bed rest, Lordship. As in Annexure 1 medical certificate, nothing transfers therefrom that the applicant was in any way advised for rest or no movement, and the said certificate only simplifies that the applicant was under treatment without any suggestion of bed rest or no movement, and hence the same not technical limitation laws.
But Mr. Peterson, learned
I have certain
applicant. And sir, your good name?
as a Bhaktiyar.
As a Bhaktiyar, learned counsel for the respondent opposite party. This application under section 5 of the Limitation Act is referred by the applicant for continuation of delay of 90 days
My lord.
in filing connected regular second appeal against the judgment and order passed by the judgment and order dated
Judgment and order dated, my lord, 26/6,
judgment
14/6,
judgment and
14.
decree dated 26/6/2020 passed by the learned civil judge Borpeta. Title appeal number
11 of 2020, my lord.
who passed the appellate judgment? First appellate court is
First appellate court, my lord, 14/3/2023.
14/3/2023
Judgment.
in title appeal number
11 of 2020.
11 of 2020.
2020.
Mr. Sen, learned counsel for the applicant submits that the applicant was not informed by his counsel about the date of judgment and decree passed by the learned first appellate court on 14/3/2023, and that the petitioner was suffering, and the applicant was also suffering from sciatica pain from 3/6/2023 to 27/9/2023. 2023, for which he could not move. For which he could not move, and therefore the appeal could not be filed in time. And in support of the aforementioned contention, the applicant has also enclosed a certificate, a medical certificate, and the prescription issued by Superintendent Forfeita Civil Hospital, Kolkata. Kolkata. And that the delay is not intentional and deliberate, and the same as duly been explained in the statement, in the paragraph number 4 and 5 of the application, and that the applicant has an arguable case, and the same is required to be heard and decided on merit, and therefore Mr. Sen contented to allow this application. Per contra, Mr. Bakhtiar submits that the delay has not been properly explained, and in the medical certificate, there is no medical advice for taking rest for the period indicated therein, and as no sufficient ground is assigned, this petition is to be dismissed. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents that must record. And the statement and averment made in the paragraph number 4 and 5 of the application, and also the medical certificate at page number 13, and the medical prescription at page number 12 and 12A. And taking note of the statement and averment made in the paragraph number 4 and 5, and also taking note of the medical certificate at page number 13 and the prescription at page number 12 and 12A. This court is of the view that the delay of 90 days is sufficiently explained in this application. So, Mr. Bakhtiar, learned counsel for the respondent submits that there is no medical advice for taking rest for the period 3/2022 to 27/9/2023. Yet, it appears that the applicant was suffering from sciatica, we can look at the right with lumbar sacral vertebral pathology. And he has also been prescribed with some of the medicine. And as such, the submission of Mr. Bakhtiar, learned counsel for the respondent opposite party, left his court unimpressed. Taking note of the submission of learned counsel for both the parties, and also considering the given facts and circumstances on the record, this court is inclined to conduct the delay of 90 days regarding the accordingly, this IA stands closed. In view of the order passed in the IA, now the rest they will proceed to register the appeal and list the same before the court as soon as practical.
Lordship may fix a date, my lord, because because my lord, some urgency is there, my lord. They have filed execution case, my lord.
No, there is already a
And-
direction as soon as practical.
My
Because
lord,
the rest they will take some time to register it.
true, my lord, that I understand, my lord, but let them, my lord, give an undertaking, my lord, that they will not pursue the
No,
execution, because
On
execution,
next day, we will consider it.
my lord, lordship may fix a date, any date, my lord, as your lordship convenient,
Yeah,
my lord,
fine.
any date. Because, my lord, otherwise it won't be listed, my lord. Since
Lordship-
execution is
Lordship-
proceeding, my lord,
any
execution case is pending, my lord,
Lordship-
they are proceeding, my lord. 2nd April.
Lordship,
I am deeply agree.
second appeal, it will be difficult for us because it will be on the occasion of Eid, Lordship. So Lordship, can it be?
Eid
after
Eid is 30 and 31st, my lord. 30
It
is
may
the
be on
Eid.
first of the April also. Lordship, can it be? Because it will be difficult for us, Lordship. Post Bihu, Lordship.
Fourth,
After Bihu.
fourth of
After
my
Bihu,
lord,
Lordship.
4th of April.
Lordship after Bihu, Lordship. Post Bihu. Lordship, it will be
So
difficult.
before vacation,
Before vacation, my lord, because otherwise, my lord, execution case is there. That is my
take
difficulty.
a date from me.
7th of April. I am deeply obliged.
Ah,
I am
Lordship,
deeply
also,
obliged. I am
we have not
deeply
received one I also. I them to give us served a copy of the I. One of the I we have not received till yet.
who say?
My lord, stay petition along with the,
Yes,
my
Lordship.
lord,
We have not
Furnish
received.
a copy too.
I'll furnish. Deeply obliged.
Much obliged, Lordship.
Excited.
Wait, because we are lordship, in this case, we need 2 weeks time to file our objection to the IA we have filed.
But on the last occasion also, Lordship, this application was filed on Lordship 10 to 2025. They did not file objection. On the last occasion also, they took time.
No, it
Yes.
is not reflected in the order, and we asked for 2 weeks, it is not reflected, it is only mentioned that heard so and so, heard so and so, heard so and so, 6 on 18. We asked for,
But
you
my
remember
friend-
2 weeks time.
Anyway, my
No,
friend,
this
Lordship,
IA is filed by which party?
my lord,
the
the
claimant.
claimant respondent for releasing 50% amount. Already, Lordship, the amount has.
No, whether the amount was
Yes,
deposited.
all amount has
I
already
think
been
deposited, lordship.
deposited. I don't know what objection, Lordship, they will file. Only taking time, Lordship. In fact, Lordship, this is there.
50% will release it because we have already
No,
admitted
lordship,
that.
because, no, lordship, because the appeal itself will be, the amount is 70 lakh something, lordship, in a injury case. 70 lakhs, something.
After judgment, he died.
That is
But-
the point, lordship. Disability amount was given to one Iqbal Ahmed and he died. So disability, that amount won't go to the father and mother and everybody, lordship, because it is personal. Then, lordship, the amount given for treatment, he said that he had spent it. So that amount also won't go. So, lordship, pain and suffering, it is personal in nature. Disability amount, personal in nature. Pain and suffering, personal in nature. Loss of enjoyment of life, personal in nature. Future medical treatment is personal in nature. So, lordship, that's why we need to file an objection. That is the reason. Because the person died, they did not inform the court that he had died. When we filed the appeal, then they came up with a petition that he has died on such and such date. And then we amended our, then they were implemented and we amended our appeal memo, incorporating this part that since he has died, the amount which were personal in nature, that they won't get. That was why we need to have it on record, Lordship.
My lord,
I pray, Lordship, maybe one
No,
week.
that's all that will consider that respect in the appeal.
No, lordship, they won't, 50% they won't get. That's why I'll give the calculation, how much they can get. Medical, maybe medical expenditure, if they can show that they had given, that is 25 lakhs, 54,680. Maybe that they will be entitled to, but not for disability. Lordship, the person has, because that is loss of income due to disability. The person has died. So how, if it is not a death case, he did not die because of the accident. He died.
Maybe, but that may be the reason for his death.
No, that they have not shown and they have mentioned it actually. That they have not shown that it was because of that he died. That is the reason,
my
Lordship.
lord, I am clarifying that position, Lordship. My friend has wrong submitted, Lordship, something is wrong. Because judgment was passed on Lordship 23/7/2021, directing them to pay the amount within 2 months. My lord, 23/7/2021, that judgment was passed. And this person, injured person, Lordship, died on 24/9/2021, after 2 months. And when we get the notice, Lordship, Lordship, of appeal of this honorable court, Lordship, then we approach before we file a petition for implementation. Accordingly, implementation petition has been allowed. And from the very beginning itself, Lordship, the claim petition that was filed by the claimant, but it was represented by the father of the petitioner because he was not in a position to move his hand because he was not able to put his signature.
Till the
So,
father won't
so
get
that is
disability
evident.
compensation,
That
Lordship.
is
That is the settled law.
that is
Lordship
evident.
can fix it next week. I'm
No, no,
ready to do
certain
the
law
even
is-
hearing.
I'm
If Lordship would
relying-
allow me to file an objection, I'll do a hearing on the hearing. Because that itself will decide the preliminary issue itself will decide.
No, at least some amount may be released in his paper, their paper.
Lordship, that is what I'm submitting. Medical expenditure 25 lakhs, Lordship, that amount that is mentioned in the judgment.
There is a latest Supreme Court
And
judgment,
what is the amount deposited before the court?
35 lakh something, Lordship.
35.
That is 50% of 70 lakhs,
Okay.
5,480.
Let 40% be released, not the entire amount.
40%.
40% कितनी होगा?
किमान होगा, I'm just calculating.
We have also Lordship
Because
filed a
Lordship,
close
once
objection.
payment is made, afterwards,
No,
even if we win, we won't be able to even
No,
vote
that's
this.
like, but that also cannot be the reason for denying their.
But Lordship, that is the settled law.
No,
This
maybe
section
settled
law
law,
that-
but
For disability,
madam, we have to keep in mind the object of the legislature in enacting the act.
My lord, we
that
also-
comes to 28 lakhs 2,192.
Take it.
my lord. We also filed a cross objection to that effect because that was due to the accident. He died.
No, no.
But he was constant under treatment, Lordship. Everything is on record. My friend, I don't know how. Otherwise,
No,
there
it
is a
is
set.
your
Anyway, your
objection.
Lordship is.
They
passing-
cannot show-
Heard Mr. M. Khan, learned counsel for the applicant, Madam R.D. Mazumdar, learned counsel for the respondent number. Madam, you have for respondent number?
No.
Lordship,
You have for respondent number?
in opposite party, actually, if appeal is asked,
Okay.
here in this Lordship, I am
Opposite
the
party number?
opposite party number one.
One.
One,
One.
2 and 3. Your name? Your name?
He did it on behalf of
P. Devi, learned counsel, appearing on behalf of the Secretary Paturi, learned counsel for the respondent number 2 and 3. This interlocutory application is preferred by the applicant for releasing 50% of the awarded amount, which has already been deposited before the registry of this court. Mr. Khan, learned counsel for the applicant, submits that the appeal has already been admitted. And the record has also been called for from the learned tribunal. And that the amount deposited before the registry of this court is required to be released in favor of the applicant. Therefore, it is contented to allow this application. The other hand, is Mazumdar, learned counsel for the respondent number 1, submits that there is objection in releasing the entire amount in favor of the applicants, since it was a case of injury, personal injury, and the person concerned has already suffered damage. And as such, he has objected in releasing the amount in favor of the applicant. Third, taking note of the submission of learned counsel for both the parties, I have carefully gone to the application under the past report, and also considering all the facts and circumstances of the record, it is provided that the sum of rupees 40% of the amount deposited before this court shall be, before the registry of this court shall be released in favor of the applicant. In terms of above, this IA stands closed.
with the bond, Lordship, with the bond.
No.
My lord, one thing, Lordship, your Lordship has said that 50% of the deposited amount.
Yes,
Then it will be, Lordship, 50%, 40% of the deposited. That means the deposited amount is 50%. And from that 50%, it will be 40%. So your Lordship may, no, it 20. Your Lordship may mention the amount. Otherwise, Lordship, they will calculate that amount because they will take that
Registry can-
50% amount, 35
No,
lakhs.
no, 40% of the awarded,
Yes, if it is awarded amount,
awarded.
my lord, one thing, lordship, 4 persons were implicated in this case, lordship, after death of the injured person, lordship. Mother, father, one child, and wife. Mother of the lordship deceased has already expired. So that amount will go to these 3 persons, 3 applicants. That's why we
For that,
we file-
lordship, they have to file
Application.
application because
and that amount, lordship, may be
face
directed
value.
to release in favor of the present applicant. We have-
No, unless an application is filed, including the death certificate,
Yes,
it will not be proper for this court to pass us. To file an IA along with this death certificate.
Hello, like,
obliged.
Lordship, may I just take indulgence in item number 6, Lordship? I'll take it for the time being, Lordship. For the time being, my junior will be praying, Lordship. Because in another case, court, my case is going on. I'll do it, Lordship.
Item number 6.
6, Lordship. Oh, no, sorry, 5. Sorry.
Okay, after some time then.
Yes, Lordship.
Okay,
Highly obliged.
My friend has
okay.
item 17. Item 4.
Well, in this case, participant, my lord, initially, my lord, the one affidavit was shown. I have already submitted before, let's see, just for feedback, my lord. Well, what is annexus 7? After the death of my father, my lord, my predeceased, my lord, sister, my lord, daughter, shown one affidavit saying that they are the legal heirs during my survival. During I am as a son, I am surviving, my lord. Thereafter, what is happened by showing this affidavit, they have mutated the plots of land, my lord, behind our back. I have filed one title suit that is pending, my lord. Thereafter, my lord, what is happened, my lord, against the said forgery, my lord, because they have done this, shown this affidavit saying that they are the legal heirs. They are Agini, my lord, they are the nicest of the, my lord, my nice, because, my lord, and my sister expired, my lord, 12 years ago. 12 years ago, before the death of my father, she expired. Her daughters shown this affidavit behind my back, my lord. Thereafter, my lord, mutated all plots of land, my lord. And our title suit is pending. Independent what is happened, my lord. The complainant, my lord, filed one CR case against, my lord, LEC, your lordship, against the, my lord, accused persons. And accused number 1 is a serviceman. He's staying in Borpeta, my lord, but his name is also incorporated here. First of all, your lordship, kindly peruse your lordship, annexus 7, page 37, my lord. Paragraph 1, we are all by birth citizen in India. Paragraph 2, that our maternal grandfather, Kamal Paramanik, son of H. So-and-so, as a patta holder having his right title and interest thereof, when he was possessing a plot of land measuring so-and-so, dag number so-and-so, prior to his death, our mother, Malika Khatun,
Mr. Das, you come to the complaint list
yes, madam, complaint petition.
because we have to confine ourselves to the
Yes, madam.
facts mentioned in the complaint.
Yes, madam, page that is 22. Dr. Farnicular, I am to read, my lord.
Yes.
গোচৰৰ সৰল গোহাৰি এই যে 28/12/2020 তাৰিখে দিনৰ অনুমান 12 মান বজাত গোচৰীয় আৰু 2 নং সাক্ষী ৰাম হৰিশ্বৰৰ 3 নম্বৰ গাঁৱত গোচৰীয় নিজ জমিত যোৱাৰ লগে লগে 1 নম্বৰ পদকীয় হুকুম মতে বাকী পদকীয়গণে পূৰ্ব পৰিকল্পিত হাতে লাঠি ফলা দা ডেগাৰ আদি চোকা অস্ত্ৰ লৈ মৰণাস্ত্ৰ লৈ হঠাৎ গোচৰীয় বাট আগচি ধৰি অশ্লীল ভাষাৰে গালি গালাজ কৰিবলৈ ধৰে। গোচৰীয়াই পদকীয়ক অশ্লীল ভাষাৰে গালি-গালাজ কৰিবলৈ বাধা প্ৰদান কৰাত পদকীয়গণে অতৰ্কিতে গোচৰীয়াক আৰু 2 নং সাক্ষীক মাৰপিট কৰিবলৈ আৰম্ভ কৰে। 2 নং পদকীয়ে হাতত থকা দাৰ গোচৰীয়াক হত্যা কৰাৰ উদ্দেশ্যেৰে মূৰত ঘঁপিয়াৰ ফলত মূৰ কাটি জখম হৈ অজ্ঞান হৈ মাটিত পৰি যায়। লগে লগে 2 নম্বৰ সাক্ষীয়ে চিঞৰ বাখৰ কৰাত 1, 2, 1, 3, 4, 5 সাক্ষী আগবাঢ়ি অহাত 3 নম্বৰ পদকীয়ে 1 নম্বৰ সাক্ষীক দাৰে মূৰত আঘাত কৰাত 1 নম্বৰ সাক্ষীৰ মূৰত দুঠাইত কাটি ৰক্তস্ৰাৱী গুৰুতৰ জখম হয় আৰু অজ্ঞান হৈ মাটিত পৰি যায়। 1 নম্বৰ পদকীয় 3 নম্বৰ সাক্ষী হাতত থকা বাঁহৰ লাঠিৰে কোবাই গুৰুতৰ জখম কৰে। 4 নম্বৰ পদকীয়ে 2 নম্বৰ সাক্ষীক মাৰপিট কৰি কাপোৰ কানি ছিঙি বিবস্ত্ৰ কৰে, ফলত 2 নম্বৰ সাক্ষীৰ শ্লীলতা নষ্ট হয়। 5 নম্বৰ পদকীয়ে 4 নম্বৰ সাক্ষীৰ দাৰে মূৰত ঘঁপিয়াই যদিও মূৰৰ দাৰ আঘাত নালাগি বাওঁ ভৰিত কাটি যায় আৰু গুৰুতৰ ৰক্তস্ৰাৱী জখম হৈ মাটিত বাগৰি পৰে। ওচৰ চুবুৰীয়া মানুহ আৰু 5 নম্বৰ সাক্ষী আগবাঢ়ি আহি ঘটনাস্থলীৰ পৰা জখমীসকল লগে লগে অসামৰিক চিকিৎসালয়ত 1 নম্বৰ সাক্ষীৰ অৱস্থা গুৰুতৰ হোৱাত চলেজ নাৰ্ছিং হোমত ভৰ্তি কৰায়। উপৰোক্ত ঘটনা সংক্ৰান্তে গোচৰীয়া পঞ্চৰত্ন নদী আদিবাসী থানাত এজাহাৰ দাখিল কৰিছিল যদিও থানাৰ ভাৰপ্ৰাপ্ত বিষয়াজনে মহোদয়ে এজাহাৰখন পঞ্জীয়ন কৰা নাই আৰু ঘটনাস্থলী পৰিদৰ্শন কৰা নাই, পদকীয়ৰ বিৰুদ্ধে কোনো ব্যৱস্থা কৰা নাই। Here, my incident was 28/12/2020, and this complaint petition was filed on 3/2/21, almost 3 months thereafter, my lord. And cognizance order, my lord, your lordship kindly peruse. Annexure 5, page 26.
Yes.
That is complainant Muslima Hatun is present. Peruse this year, including the complaint petition. I have gone through the complaint petition. The statement of the complainant to witnesses under section 200 CRPC, along with the materials in the case record, heard the learned counsel. On such perusal of hearing, I find prima facie materials of offence under section 147, 149, 448, 294, 324. All sections are there, man. IPC against the accused person Hazrat Ali Kazimuddin Mufidul Jaharan so and so. Issue summon to the accused persons above named. Here, Lordship earlier occasion observed that, my lord, this order, a speaking order has to be there at least, my lord. That was judgment followed by the Honorable Apex Court. The Lordship observed regarding this essence of the order, my lord. Because statement what has been recorded is also here.
What was the judgment?
That judgment, my lord, 2015-12 SCC 420, my lord. Page 20, paragraph 22. Here, my lord, placing term is that, my issuance of process to accused complaint case, prerequisites of for duties on the part of the magistrate concerned while passing the said order, application of mine to relevant
What is the
issues.
citation?
Lordship,
Citation.
citation 2015-12 SCC 420. Mehmood regarding speaking order has to be there.
Paragraph number?
22, mark there, my lord.
whether there was any medical certificate while taking cognizance by the learned trial court under section 326 307.
I have not checked, my lord. Because incident was 2 months ago there.
Maybe, but the question is whether there was any medical document before the court.
That report is there possibly in the records. Whenever I am going to the into record aspect, it will be, I'll say. Again, I want to, my lord, I want to place the paragraph 9, my lord. So for accused petitioner number 1, at the relevant point of time, he was, my lord, in Borpeta, my lord. Just I want to place the paragraph 9, my lord, page 9. Just I am reading, my lord.
Yes.
Your petition begs to say petitioner number Hazarat Ali Ahmed, who is the headmaster of the Masner Alga High School situated at Dhubri, who is also resident of Dhubri. It is to be pointed out herein that he was neither present on the day of the incident on 28/12/2020, nor he had involved in that case. As per proof of evidence, the inspector of the school Dhubri District Circle has issued a certificate 27/5/22 mentioning herein that on the day of the incident, your petitioner 1 was present in the school on 28/12/2020, which was based on teacher's daily attendance register of that school dated 28/12/20, my lord, from 8 a.m. to 3 p.m. Prima facie, it is also not somehow possible that your petitioner 1 could travel from Dhubri to Goalpara, vice versa, when with a movement time which is about all total 300 kilometers, crossing the distance for both up and down. Hence, this inclusion in the complaint petition is not at all correct. Rather, it may be without any implication, my lord. Here, my lord, I want to place the documents annexure 10, page 47. Hazarat Ali petitioner number 1, my lord.
Page number?
Page 47. Is headmaster, is a headmaster, my lord, of the Masner Alga High School. Annexure 1 is the I card. Second was annexure 11, page 48 is the certificate, my lord. Inspector of the school issued. As per the attendance register, it is seen that Hazarat Ali Ahmed, headmaster in charge, Masner Alga High School, was present in the school on 28/12/2020, my lord. Thereafter, my lord,
When the occurrence took place.
on that day, my lord, 28/12, they have mentioned in the complaint, they have mentioned both
At
time is
what
also there, my lord. 28/12/2020 দিনৰ সময় অনুমান 12 মান বজাত thereafter, my lord, annexure 12, page 49. This certificate, all the teachers mentioned below of Masner Alga High School were present at school on 28/12/2020, time 8 a.m. to 3 p.m. This was thereafter, my lord, visiting report. Even on that day, one visiting report was also there. Cluster resources program. Today, I have visited Masner Alga High School. During my visit, I have found that all teachers and non-teaching staff from serial number 1 to 16 of attendance register are present at school 9 a.m. And my lord, his attendance register also shows that same, my lord, teachers daily register, it is mentioned on 28/12. Entry exit time is also specifically mentioned 8 a.m. to 3 p.m.
Yes.
So, my lord, my prayer is that, my lord, my title suit is also pending there, my lord. Title suit, that is, my lord, just I am to place, my lord, regarding that same cause of action, title suit against them, my lord. That is page 28, my lord. Now 27, annexure 6. Kazimuddin Paramanik. And my lord, relevant paragraph I want to read, my lord. Just first paragraph, page 28. This, my lord, defendant Momtaz Begum, Muslima Khatun, all are the complainant witness mentioned here. She is the complainant also, my lord. The father of the plaintiff named Kamal Paramanik was the absolute owner, possessor, and pattadar of the land measuring so and so.
When this title suit was filed,
It was filed, my lord, on my lord. Title suit file because as November 21, my lord. Because, my lord, we did not able to get the copies also. I have specifically mentioned here, my lord. Paragraph 5 in the title suit. In the title suit mention, a few letters went to the office of the circle officer. Paragraph 5. Balejana Circle Gorpara with a petition for certificate copy of the Sita, Jawanmundi, surveyed village in the respect of ABCD land. But the office of the defendant number 10 refused to take the copy of the petition. Having no alternative, the plaintiff number 4, 12, 20 filed a petition under section 6 seeking certificate copies of the order of the mutation case of the Sita, Jawanmundi of below scheduled lands. And the defendant number 10 received the RTA petition, but denied to provide any receipt of the said petition. And the said, my lord, page 28, just, my lord, I am to place the relevant paragraph, my lord, in the title suit. The father of the plaintiff named Kamal Paramanik was the absolute owner, possessor, and pattadar of the land measuring so and so, Assam height number so and so. These lands have been more specifically described in the schedule ABCD plaint, my lord. That the father of the plaintiff, Kamal Paramanik, had 2 children, plaintiff and Malika Khatun. Out of these 2 children, Malika Khatun died before the death of her father, Kamal Paramanik. Malika Khatun passed away 12 years ago from today, leaving behind the defendant number 1 to 7 as her legal heirs and successors. The father of the plaintiff died on 13/6/2020, leaving behind the plaintiff as his sole heir and successor. Since both the plaintiff and defendant 1 to 7 are governed by the Mohammedan law of succession and inheritance, the mother of the defendant 1 to 7, being predeceased daughter, is not entitled to inherit the properties left by the father, Lloyd Kamal Paramanik. Hence, the defendant number 1 to 7 are not entitled to any share. The paragraph 4, my lord, that after the death of the father plaintiff, the defendant number 1 to 7, in collusion with the defendant number 10, mutated their names in the revenue records ABCD schedule land as their legal heirs of Lord Kamal Paramanik as per the order dated 6/10/2020 passed by the defendant number 10 in mutation case number so and so. When the plaintiff went to the office of the defendant for mutating his name in the revenue record, he came to know that the defendant number 1 to 7 in connivance with the defendant number 2 illegally and unlawfully without following due procedure mutated their names in the revenue record. That was the actual manner of incident, my lord. And that's why, my lord, my CR case is also pending, my lord. That CR case for that forgery, that is, I have annexed here, my lord. Yes, my lord, 43. And relevant person, page 44. Relevant person 44. Here, my lord, গোচৰীৰ দেউতা টিয়াপাৰা গাঁৱৰ বাসিন্দা হয়। মাটিৰ গৰাকী আছিল 13/6/20 তাৰিখে গোচৰীয়া দেউতাই তেওঁৰ একমাত্ৰ ল'ৰা সন্তান অৰ্থাৎ গোচৰীয়াক ইহ সংসাৰত এৰি পৰলোক গমন কৰে। উল্লেখযোগ্য যে 3, 4, 5, 6, 7, 8 আৰু 9 নম্বৰ পদকীয় গণৰ মাতৃ মালিকা খাতুন গোচৰীয়াৰ ভনীয়েক আছিল যদিও গোচৰীয়াৰ দেউতাক অৰ্থাৎ কামাল পাৰামানিকৰ মৃত্যুৰ প্ৰায় 10 বছৰ পূৰ্বে তাইৰ মৃত্যু হৈছিল। এই অৱস্থাত গোচৰীয়া আছিল মৃত কমল পাৰামানিকৰ একমাত্ৰ উত্তৰাধিকাৰী। 3, 4, 5, 6, 7, 8 আৰু 9 নম্বৰ পদকীয় গণৰ মাতৃ মালিকা খাতুন আছিল কামাল পাৰামানিকৰ প্ৰিডিচিছ ডটাৰ। এই অৱস্থাত 1 নম্বৰ 2 নম্বৰ পদকীয়ৰ সৈতে লগ লাগি বাকী পদকীয় গণে উল্লেখিত গোচৰীয় মৃত দেউতাকৰ জমিখিনি অবৈধভাৱে বেদখল কৰাৰ উদ্দেশ্যেৰে ষড়যন্ত্ৰমূলকভাৱে গোচৰীয় জীৱিত থকা অৱস্থাত তেওঁৰ মৃত্যুৰ প্ৰমাণ প্ৰামাণিকৰ কোনো জীৱিত সন্তান নাই বুলি 9/10/2020 তাৰিখে গোৱালপাৰা আদালতত উপস্থিত হৈ নটাৰী সিদ্ধিনাথ পাটগিৰিৰ সন্মুখত অধিবক্তা ওছমান গনিয়ে চিনাক্ত কৰি দিয়া মতে এখন মিছা শপতনামা সম্পাদন কৰি গোচৰীয়ৰ মৃত দেউতাকৰ নামত থকা উপৰোক্ত জমিখিনি উক্ত মিছা শপতনামা বালিজানা ৰাজহ চক্ৰ বিষয়াৰ কাৰ্যালয়ত জমা দি জমিখিনি 3, 4, 5, 6, 7 আৰু 9 নম্বৰ পদক্ষেপৰ নামত বেআইনীভাৱে নামজাৰি কৰি আত্মসাৎ কৰি লয়। এই বিষয়ে গোচৰীয় সন্দেহ হোৱাত RTI যোগে বালিজানা চাৰ্কেলত এপ্লিকেশ্যন উক্ত তথ্যসমূহ পাছত গোচৰীয় ঘটনা সম্পৰ্কে 1/3/2021 তাৰিখে এখন লিখিতভাৱে এজাহাত দাখিল কৰে। যদিও গোৱালপাৰা থানাৰ পুলিচে আজিলৈকে সম্পৰ্কত তদন্ত কৰা দূৰৰ কথা কোনো গোচৰ পঞ্জীয়ন কৰা নাই, যাৰ ফলত গোচৰীয় ন্যায্য প্ৰাপ্তিৰ পৰা বঞ্চিত হ'ব লগা হৈছে। That order is, my lord, next page, in matter was sent to the police, my lord, page 46. The net magistrate, my lord, pass order, my lord, judicial magistrate first class. Consider only, I deem it fit to exercise my power under section 156(3).
Okay, okay.
Yes, ma'am.
Now you tell me, after going through the complaint petition, can it be said that no offense is made out against you?
My lord, as civil, yes, my lord, civil case is pending, my lord, and this order what has been mentioned, passed, my lord, by the learned court below, my lord, appears to be not page 26, annexure 5, my lord. All sections are added, but there is no any mention about the, my lord, contents of these sections, my lord.
Okay, Mr. Das?
Lordship, let us go by the sequence of events, Lordship. That the complaint, the present complaint was filed on 3/2/2021, Lordship, describing that there is a offense committed by the respondents herein. They approached the police, and thereafter, having failed to get the case registered, they approached the court, Lordship. And in between the period, that has been the delay has been caused, Lordship. I have checked the record as well as the e-court system, Lordship. The complaint was in fact filed on 3/2/2021, Lordship, present complaint.
And when the occurrence took place?
Occurrence as per the contents of the complaint, it took place on 28/12/2020, Lordship. And they immediately approached the police, Lordship.
2020.
20. And Lordship, and subsequently, Lordship, the
So, is there any explanation for the delay of almost
they
three-
have explained, Lordship. They explained উপরোক্ত ঘটনা সংক্রান্তত I am reading from page 22, Lordship. সংক্ৰান্তে গোচৰে পঞ্চৰত্ন নদী থানাত এখন এজাহাৰ দাখিল কৰিছিল যদিও থানাৰ ভাৰপ্ৰাপ্ত বিষয়া মহোদয়ে এজাহাৰখন পঞ্জীয়ন কৰা নাই আৰু ঘটনাস্থলী পৰিদৰ্শন কৰা নাই and পদক্ষেপৰ বিৰুদ্ধে কোনো ব্যৱস্থা লোৱা নাই. This is explained.
So, where is the copy of that FIR?
That copy
Is it part of the
is not available. It is not available with the. I don't know if it is available with the record. But the prima facie, the court has taken cognizance after going through the not only apart from the materials in the complaint, he has recorded
No,
the
no,
depositions of two witnesses.
You say there is delay of almost 8 months. So you have to
Not
explain
8 months.
the-
Not 8 months, but 3 months. December 2022,
Yeah.
and complaint is filed was 3/2/2021. Almost not even 3 months. 1 month, few days.
Maybe. But there is one explanation. But where is the document to substantiate that explanation? Where is the copy of the FIR that you have filed before the river police?
Lordship, that the prima facie, when the matter is presented before the learned magistrate, the learned magistrate went through the material present available in the complaint, Lordship, and he took the depositions of witnesses, Lordship. Having found the materials, he issued process, Lordship. And And so, when the respondents accuse, they will appear before the learned trial court. Then the other things will follow. So whether this entire complaint case is at all maintainable or not, they can very well raise this issue before the learned trial court also, Lordship. But having not annexed, I don't know, Lordship, if it is available with the record or whether they have presented before the learned court, learned trial court. Lordship, I am not privy to that, Lordship. But on the after the receipt of the complaint, learned magistrate recorded the depositions of witnesses, Lordship. Having found the material, prima facie material, Lordship, he issued the process, Lordship. And the defense taken by the respondent accused regarding the title suit, Lordship. The title suit is in fact filed on 1/12/2021, Lordship. Much after the present complaint case was filed, Lordship. 1/12/2021, Lordship, I have checked on in the e-court system, Lordship. And thereafter, they filed the and thereafter they filed the complaint case, Lordship. 1/2022 on 3/1/2022, Lordship. In order to make out a case in their defense, Lordship, they have filed these two cases, Lordship. Now they are before your Lordship for quashing, primarily basing on the materials available on these two cases, Lordship. Title suit is pending, cases of civil nature, and the other things that they have expired in their complaint case, Lordship. This is the primary defense, Lordship. And regarding the cognizance order, Lordship, at page 26, Lordship. On the last occasion also, Lordship put me this query regarding the what is my explanation regarding this order, Lordship. As the magistrate has not in detail recorded any reasons while issuing the cognizance. For that, Lordship, if we go by the spirit of section 204, Lordship, CRPC.
No, that is there, but are we not supposed to follow the decision of Supreme Court?
But there are other catena of judgments, Lordship, I'll place before your Lordship, which says that magistrate is not required to go in detail regarding the reasons while
But
issuing
the prima facie satisfaction has to be
prima facie
recorded.
satisfaction, Lordship. That is the main.
No, here say the cognizance is taken under section 324 and 326. Where is the medical document to show the injuries, nature of injury?
Lordship, peruse this, if I may read, Lordship. Complainant Muslima Khatun is present. Peruse this here, including the complaint petition. I have gone through the complaint petition, the statement of complainant, two witnesses under section 202, CRPC, along with the materials on record, heard the learned counsel, Lordship. This the prima facie the satisfaction on the part of the learned magistrate has been recorded,
No,
Lordship.
no. In order to take cognizance of the offense under section 824, 826, 36,
Lordship.
there must be medical document to show that to show the nature of injury.
Lordship.
826, it must be given.
Yes, Lordship. Lordship, that whether those documents are available on record or not, and
No, whether
but the Lordship, I may
cognizance
place
can be taken merely on the basis of the statement of the witnesses under section 324 and 326.
Hmm.
Where? Maybe, but whether he has taken into account.
Lordship, with regard to this, particularly to this issue, Lordship.
Then what is the nature of injury, Mr. Doctor?
Extracalculatory soft tissue failing over frontal convexity. This kind of brain also. He was admitted for, on 26/5/12 and discharged on 26/12. Next day. Normal, no texture is there. No. Soft tissue scrub rosin.
Swelling also, swelling.
It is
So, going by the order and the medical certificate, can it be said that the court below has applied its mind?
has to be, go to the that report also because it has because the primary requirement is that also they has to file first approach the police officer, police station, thereafter the SP concern, thereafter the court below.
May not be in all the cases. He may directly go to the hospital also. He can obtain the report there
That
to
report
show
that,
that the injury is sustained by him in previous.
that report has none, that the report is not available, that report is not called for as per record also. And one the earlier there is a direction to ask lordship to the state lordship that whether there is any case filed or not, that person is required to take.
You see, there is a delay of almost less than 3 months. Less than
1 or 2 days.
months.
Not 3 months. The December 28
Then there
December.
is also material to suggest that on the relevant date, the accused number 1 is in Dhuburi. He was
That,
working as
all these things they can very well take as their difference during trial also. During trial, because only someone
No,
has
maybe. But they are before this court by filing this petition under 480.
Lordship. No, Lordship, whether this honorable court will go into the robbing inquiry, where there may be some, there may be,
inquiry prima facie.
there
It
may
is the
be,
certificate issued by the inspector of school.
Lordship,
And
whether
this attendance register prima facie is also
these are subject to substantial corroboration at the time of the trial, Lordship, whether that certificate is
those
genuine or
documents
not.
were-
The person who has issued that
those
certificate, that
documents
is also
were
required to be.
issued by the
into-
government servant.
Lordship,
Inspector
but
of school.
prima facie, Lordship.
So prima facie,
Prima facie, Lordship,
it is in
this
their
is
favor.
at the case is at the stage of issuing summon, Lordship. So there is no, they can, the defense they have prepared, Lordship, the title suit and other case pending. They can very well take the defense during at the time of trial, Lordship.
So that's
And-
all right.
And regarding the reasons to be recorded by the learned magistrate, Lordship, that point was made clear by the Honorable Supreme Court in the year 2012, Lordship, specifically on this point, Lordship. It's Lordship 2012 ARSC 1747.
Relevant paragraph.
Relevant paragraph, Lordship. The paragraph 5, Lordship, in which the questions were framed by the Honorable Apex Court, Lordship. The questions which arise for consideration in these appeals are whether taking cognizance of an offense by the magistrate is same as summoning as an accused to appear, whether the magistrate, while considering the question of summoning an accused, is required to assign reasons for the same. The second question is more relevant for us. Lordship, if we go by, there are then the section 190 and 204 is discussed, Lordship, and page paragraph 7, Lordship. There are discussions from earlier Supreme Court judgments also, Lordship. In SK Sinha, Chief Enforcement Officer versus Videocon International so the expression cognizance was explained by this court as it merely means become aware and of and when used with reference to a court or a judge, Lordship. And then, Lordship, paragraph 10. The Section 204 of the code does not mandate the magistrate to explicitly state the reasons for issuing summons. It clearly states that if in the opinion of the magistrate, cognizance of an offense, there is sufficient ground for proceeding, then the summon may be issued. The section mandates the magistrate to form an opinion as to whether there exists a sufficient ground for someone to be issued, but it is nowhere mentioned in the section that explicit narration of the same is mandatory, meaning thereby it is not a prerequisite for deciding the validity of the summon issued. Then Lordship, paragraph 11. Time and again, it has been stated by this code that summoning order under section 204 of the code requires no explicit reason to be stated because it imperative that the
No,
magistrate.
Mr. Does no
Yes.
explicit reason does not mean that there should not be any reason. There must be some reason.
Lordship, the magistrate has recorded his satisfaction in the first paragraph, Lordship. He has gone through the complaint.
So where it is
record-
mentioned that he found sufficient ground for proceeding against the petitioners?
No, Lordship, on such perusal and hearing, I find prima facie materials of the offense under section so and so. This is the prima facie material. His satisfaction has been recorded after going to the material of the complaint as well as the depositions recorded by the witness. And then Lordship, paragraph 12. Lordship. In Kanti Batrasa, another versus state of West Bengal so and so, it is the following passage will be opposite in this context. If there is no legal requirement that the trial court should write an order showing the reasons for framing a search, why should be already burdened the trial courts be further burdened with such an extra work? The time has reached to adopt all possible measures to expedite the court procedures and to sort out measures to avoid all roadblocks causing avoidable delays. If magistrate is to write detailed orders at different stages merely because the council would address arguments at all stages, the snail paced progress of proceedings in trial courts would further be slowed down. We are coming across interlocutory orders of magistrate and session judges running into several pages. We can appreciate if such a detailed order has been passed in culminating the proceeding before them, but it is quite unnecessary to write detailed orders at other stages, such as issuing process, remanding the accused to custody, framing charges, passing over to the next day, so and so lots. Then paragraph 13 lots. In Srimati Nagawa versus Biranna Silagappa Kolazapi and others, and this court has held that it is not the province of the magistrate to enter into detailed discussion on the merits or the demerits of the case. It was further held that deciding whether the process should be issued, the magistrate can take into consideration improbabilities appearing on the face of the complaint and the evidence laid by the complaint in support of the allegations. The magistrate has been given an undoubted discretion in the matter, and the discretion has to be judicially exercised by him. It was further held that once the magistrate has exercised the discretion, it is not for the High Court or even this court to substitute its own discretion for that of the magistrate or to examine the case on merits with a view to find out whether or not the allegations in the complaint, if proved, would ultimately end in conviction of the accused. And then in the Deputy Chief Controller Imports and Exports versus Rosanlal Agarwal, so and so, the one relevant line was at the stage of issuing process to the accused, the magistrate is not required to report reasons. Then lots, the legislature has states need to record reasons in certain situations such as dismissal of a complaint without issuing process. There is no such legal requirement imposed on a magistrate for passing detailed order while issuing summon. The process issued to accused cannot be was merely on the ground that magistrate had not passed a speaking order. In UP Pollution Control Board versus Bhupendra Kumar Modi and so, in paragraph 23, held under, it is a settled legal position that at the stage of issuing process, the magistrate is mainly concerned with the allegations made in the complaint and or the evidence laid in support of the same, and he is only to be prima facie satisfied whether there are sufficient grounds for proceeding against the accused. Same has happened here, lots. He has gone through the complaint and gone through the evidence laid by the in support of the complaint, lordship, and he has recorded his prima facie finding. This being the settled legal position, the order passed by the magistrate could not be altered
No,
with
Mr.
only
Das,
on the ground, lordship.
or the evidence laid in support of the same,
Lordship.
whether what evidence was laid by the complainant, it it mentioned in the order dated 4/12?
Lordship, the complainant and two witnesses under section 202 CRPC. That is recorded, Lordship. This is a prima facie observation of the learned trial court, Lordship. That is what is required, Lordship.
Yes, Mr. Locker?
Assuming, Lordship, assuming your Lordship holds that the order is had to be a speaking order, Lordship. For that lacuna, for the lapse on the part of the trial court, learned magistrate, whether the materials that has been presented in the complaint as well as the depositions of the in support of the complaint, Lordship, whether the materials can be washed away, Lordship. That is the point is also required to be looked into.
I don't think, but that has to be examined in the light of the other facts and circumstances of the record. There is delay of more than 2 months, then there is no material to support the contention that one FIR was filed before the river police.
That statement was made, Lordship, in the FIR.
Then there is no medical document to suggest that the injuries sustained by the victim
Lordship.
are previous in nature.
Lordship, with all respect, Lordship.
So, whether these facts and circumstances goes to show that the magistrate has applied his mind.
Also, with all respect, Lordship, these are the minute details of the case, Lordship.
Not
Whether
minor
Lordship,
details, but when the petition is filed under section 482, this court has to consider this as well.
Lordship, whether there is prima facie case or not, that is also required to be considered by this honorable court, Lordship.
Definitely.
Lordship. With all respect, Lordship.
Yes, Mr. Lockwood.
In this case, Lordship, their prayer is to initiate and process, Lordship, not to register a case through the OC, Lordship. So, Lordship, and thereafter, Lordship, honorable court, trial court has taken the deposition of the three witnesses, Lordship. And these three witnesses deposition, they have specifically mentioned, Lordship, what the incident happened, Lordship. And thereafter, Lordship, now I have come across the medical report, Lordship. Here is another medical report, CT brain pain, Lordship. Brain scan, CT scan of brain, Lordship, where there is some subcranial hemorrhage with file-based confusion in bilateral, temporal, and right sylvian external space. So there are some injuries are there, Lordship, in brain also, Lordship. And thereafter, when there is a assault on the brain, forehead, Lordship, so there is a question of 307 is also comes to Lordship. So, Lordship, and thereafter, Lordship, now the question arises, Lordship, whether the trial court, the learned court below has while passing the order of process, Lordship, initiated the process, Lordship, whether that order is a speaking order, whether there is a ground has been narrated or not, Lordship. And as per the honorable apex court judgment, Lordship, that now just it is laid out, Lordship. It is mentioned that it is not required at all that even there is a process has been initiated, Lordship, that reason is not required to explain, Lordship. And the order, Lordship, itself, Lordship, when the order itself says, Lordship, the complaint Muslima Khatun is present, peruse the CR including the complaint petition. I have gone through the complaint petition, the statement of complaint, and two witnesses under section 200. CRPC, along with the materials in the case record, heard the learned counsel on such perusal and hearing, I find prima facie material. So that thereafter the sections are narrated, Lordship. sections are stated, Lordship. So, Lordship, to my submission, Lordship, that learned court below has rightly passed the order, Lordship. There is the explanation is also there, Lordship. But if that if explanation, Lordship, that what happened, what is there, what is not there, why that court learned trial court is going to pass the order of initiating the process, summoning the accused, and it will be a it will amount to a judgment and of the entire process order, Lordship. So, Lordship, at this stage, Lordship, let the trial court be satisfied with the evidences, with the statements what they have stated in their depositions and complaint petition, Lordship.
Okay. Heard Mr. H. Das, learned counsel for the petitioner, and Mr. D. Das, learned counsel for the respondent number.
Question number 2.
Respondent number 2, and Mr. P. S. Lawford, learned additional for the lead respondent number 1. Argument concluded, order is there.
Lordship.
I'm giving two judgment, my lord. Need to. No question. এখানে যাই দিই তাহলে
Lordship, there are 2 more judgments on the similar issues, Lordship.
Not necessary to multiply.
what is the power of the Honorable High Court, my lord, to interfere, my lord, everything, my lord. Therefore, related to another is, my lord, if their civil likeness is
This Pepsi Food Limited, this decision is of 1998, was prior to the decision referred by you. And whether this decision was taken into account in that decision, it is not known. But if we go by the doctrine of precedent, that we have to follow this 1998 decision.
Yes, Lordship.
nineteen 1990. More than
Hey, Kumar, he answered into a form, ক্ষতি কম দিচ্ছি, গভর্নমেন্টে বেশি হচ্ছে। তোমার কত আছে?
Yes.
This, my lord, paragraph 5 actual facts he has given. Now, next page, C. The house pension in Schedule A is a community prayer hall of Nelly Satsang Kendra Mandir by followers Satsang counting the Nelly area, including followers friends. That I am, my lord, I am the Rayati Patta holder of land measuring 2 bigha out of 49 bigha, 1 katha, 17 licha of Dag number 2, redeem Grand Patta number 1 of village number 1, Delhi Bagisa, under Moja number so and so, so and so. And 1 katha out of 14 bigha, 4 katha, 12 licha of land covering Dag number 3, redeem Grand Patta number so and so. So and so road for Assam. Father Sri Habul Batra, legal heir of late Lasso Batra so and so, so and so. Is a Rayati Patta holder of land measuring 2 bigha covered by Dag number 2, 60 new by redeem Patta number 1 of Nelly Baisa. So, my lord, this Habul Bhatra is Rayati Pattan of Rayati Patta holder of 2 bigha land in respect of Dag number 2. And petitioner is Rayati Patta holder in respect of 2 bigha out of Dag number 2 and 1 katha of Dag number 3. Then paragraph E. I being a Rayati Patta holder along with Habul Bhatra, legal heir of Lasso Bhatra, have given no objection for the land measuring 4 bigha 1 katha in favor of Satsang Kendra Nelly for construction of prayer hall from premises on so and so. The land measuring 4 bigha so and so under possession and enjoyment of Satsang Kendra. That position so and so. So this is his malad. Other evidence is, or malad, if your lordships can see, everybody has said that it is land acquired, government land, so and so. And now his cross may be seen, my lord. Just next page. First line only.
Hmm.
I have no land in Dak number 3 of Surpatta, situated in village number 1, Neliban. Cross. So what, my lord, they can give? They can give only the land of Dak number 2, not of 3. And one they have said that it was given for road. And that was acquired by government of Assam, Sealing Act. 3 bigha 1 kata for I have nothing to say about it, but that 1 kata is nothing.
Hmm.
So this is absolutely without considering the evidences, my lord. The learned judge has perversely delivered the judgment on perverse appreciation of facts, my lord, totally. And where from this Righty Act come, my lord, I don't know. He said that 2 bigha has been acquired on Righty Act. I don't know whether the Damavati did not say that. Only 3 bigha and odd has been acquired under Sealing Act. There is no Righty Act, my lord. So totally perverse, my lord. My lord, my humble submission that so far my suit is concerned for 9 bigha should be decreed, my lord, because I have nothing to say so far. Hanu Goala and Habur, my lord, this is in respect of 4 bigha land of Dag number 2. Let them enjoy, my lord. I have nothing to say. But if under pretext of Dag number 2, they enter into Dag number 3, they are liable to be evicted. Because that is our highland. Legitimate. Because he said that he has writing Khatian only in respect of 1 katha of Dag number 3, which he has given for road. And 4 katha, 4 bigha, both Apul and he has given to the Satsang Bihar of Dag number 2. All other persons have same plea, same plea in the written statement as well as the evidence that the land is a Sealing surplus land and they have been occupying it. So, but so far 9 bigha and all the land is concerned, the scheduled land is concerned, that is not a Sealing surplus. So the learned Judge Malor has totally gone perverse. Without considering the evidence and materials on record, he has come to this. We have produced a certificate copy of the Jamavani also, which reveals, my lord, that notice there, my lord, that this 3 bigha 1 katha acquired. And it shows that 9 bigha is still in the name of Pakistan. Exhibit 2 is that.
That Jamabandi is exhibited in the court.
Yes. Yes.
Yes,
Exhibited. Exhibited.
Exhibit.
Exhibit 2. Exhibit 2. Exhibit.
And it shows that
It shows, my lord,
that
that
number 3,
my lord,
that number 3
yes,
is not in the name of the Kanugola.
not the name of.
Kanugola.
No. Well, only it shows, my lord, that 3 katha, 3 bigha and odd has been acquired under Sealing surplus land. Rest 9 bigha remains in our possession.
So it shows the name of the original pattada.
Original.
That's the basic thing. And the original pattadas are not before the lot.
That we have.
Neither their legal heirs are before your law. Except one.
My lord, we have given the attorney, my lord, power of attorney, my lord, that it is, my lord, in the name of the, my lord, now everything is conducted under the company's name and the company is doing it. And they are the shareholders of the company.
So original,
Well,
let him complete. So original Pattadar is Lakshmi Narayan Sarak,
yes,
Dock number 2.
yes. No, they are jointly, my lord, all. They are jointly partners.
There are 5 Pattadars.
Yes, 5 partners.
Okay.
And now they have not opposite, my lord, the son of the Askan Jalan, who is, my lord, because after the death of the father, he became the director of the company and he has filed the suit, my lord, that is in the name of Gopal. And everything has been mentioned, my lord, there. My lord, in paragraph 3 and 4 of the plain, my lord, we have stated everything. These facts are not considered at all, my lord, by the trial court. These are not. He has gone, my lord, that these are stealing surplus, other things, my lord. Righty copy and righty act. We have said everything. These facts also we have stated in our statement. Who has died, who has done, well, everything. Paragraph 3 and 4. They are joint owners. They are joint owners. And the one of the owners has filed the suit because the others has become the director of the company. Their sons and all.
Okay.
So they are all the perverse, my lord. The finding whatever reported by the trial court is totally perverse. Much. Very, not at all.
Let's start at 2 o'clock.
At 2. At 2, my lord.
One thing I'll just clarify on that issue. Sir. The case has been filed by Pramod Jalan. Now, who is Pramod Jalan? I'll straightway take your lordship. I'll straightway take your lordship to the copy of the Jamamandi, your lordship. That is exhibit 4. Sorry, exhibit 2. Has the lordship got it?
Yes.
Now the lordship will say, as it is admitted, your lordship, I'm sorry. Akshar Jalan's name is there. Lakshmi Narayan Saraf's name is there. Baharlal Dasani's name is there. Satyanarayan Kalani's name is there. And Narayani Devi's name is there. They are the partners of this land.
Where is the name of Pramod Jala? Who has filed this? His name is not there. So the original pattadars were Akshar Jalans, Lakshminarayan Saraf, Baharalal Dasani, Satyanarayan Kalnani, and Narayani Devi. Of course, Narayani Devi's sons is Akshar Jalan, and Akshar Jalan's son is Pramod Kumar Jalan. But has he been incorporated as legal here? It is his document who has exhibited it before the Honorable Trial Court. And he has relied on this document. So Pramod Jalan is not the legal heir, first of all. Secondly, if your lordship takes my written argument, we'll turn to page 2, Roman 3. I'll cut short the arguments here. Lordship, I'll just purely on law point here. Lordship. Page 2, Roman 3.
Yes.
The appellant plaintiff Gopal Krishna Tea Company Private Limited is a registered company wherein the pattadars were the directors. That is Akshar Jalan and all those peoples, but not this Pramod Jalan. I can bring anybody as a director of the company. I can name any outsider as the director of the company. No issue to that effect. The company law supports that. But to be a legal here, but to be only my legal heir can inherit my property, provided there is not a will. Of course, Akshar Jalan died leaving his son Sri Pramod Kumar Jalan as his legal heir, who is representing the appellant plaintiff Gopal Krishna Tea Company Private Limited. The Pattada Lakshminarayan Saraf also died, leaving behind his son Sri Pradeep Kumar Saraf, who is implicated as pro forma defendant number 20 in the title suit. The Pattada Sri Bharalal Dasani also died, leaving behind his son Sri Prakash Chandra Dasani, who is implicated as pro forma defendant number 21 in the title suit. The Pattada Srimati Narayani Devi also died, leaving behind her son S. Aksar Lal Jalan, who also died, leaving behind his legal heir, Sri Pramod Kumar Jalan. So Pramod Kumar Jalan has been brought as a director of the company, not as a legal heir of the plot of land. So how can he claim right title and interest over that? And in this document, it is their own document. Where is the name of the company? Gopal Krishna Tea Company Private Limited, represented by such and such. There is no such. So therefore, in my humble submission, the suit could not have been filed by Pramod Jalan. Sorry, could not have been filed by Gopal Krishna Tea Company Limited, because the land at no occasion, at no point of time, got transferred in the name of Gopal Krishna Tea Estate Limited. So the trial is not maintainable itself. Sorry, the suit is not maintainable in itself. Second point. Now your honor will come to page 9 of my written submission. Page 9. Serial number 6.
Yes.
Has the lordship got it? Now Roman 1. Suit has been filed by Messrs. Gopal Krishna Tea Company Private Limited, as can be seen from the print of the title suit. Readings is paragraph 6 as well as paragraph 10 also, your lordship. After plaint further confirms that the case has been filed by Gopal Krishna Tea Company Private Limited through a board resolution dated 16/5/2011, and further confirming that in the last line of the that the plaintiff is the Gopal Krishna Tea Company Private Limited. Prayer as mentioned in prayer A is for declaration of right title and interest of the Gopal Krishna Tea Company Limited. So where is Gopal Krishna Tea Company Limited? Is the Pattadar in this clan? No. So how can a court grant a right title interest in favor of the maybe a non-existent persons, maybe against an entity, if they are not named as a Pattadar, your lordship? Then your lordship will kindly touch. Schedule A suit plan is 9 bigger, 3 katha, 8 tacha, falls in bag number 3 of Redeem Grant, Patta number 1 of village number 1, Nehru Bagija Kisa, Moja, Uttarpula district, Kurigaon. As per pleadings of the paragraph 4 of the title suit, the Pattadas of the opposite land are Akshar Jalan deceased, Lokinaran Sarab deceased, Bharalal Dasani deceased, Sri Satyanarayan Kamlani surviving, and Sri Narayani Devi deceased. Plaintiff also exhibited the Jamavanti's plaintiff exhibit number 2, which I've just read now, your lordship, further confirming the names of the Pattadars. Except Satyanarayan Kamlani, all other Pattadars have passed away. All the Pattadars were the directors of the company. One of the legal heir of the opposite Pattadars who passed away substituted his director as the director in the company, except the Pattadar Sri Narayan Kamlani, who himself is the director. Herein, the respondent defendant submits that a company is a distinct legal entity, a corporate body separate from its member, as envisaged in Salmon versus Solomon and Company Limited, which is a salient features of the company. The opposite proposition of the company law is further upheld in paragraph 90 of the judgment by the Supreme Court, which I've already given along with it. I'll just read that. Of the judgment by the Supreme Court of India in the case of Life Insurance Corporation of India versus Escorts Limited and others, civil appeal such and such. While it is firmly established that ever since such and such, I'll just take the judgment in order. That is at paragraph 90. So lordship, kindly take the judgments, serial page number 334. The lordship, page number 334, it's on the left side, the page number.
Yes.
Para 90.
Hmm.
Right. It was submitted that the 13 Teparo companies were 13 companies in the name on. They were but one, and that was an individual, Mr. Swaraj Paul. One had only to pierce the corporate veil to discover Mr. Swaraj Paul lurking behind. It was submitted that 13 applications were made on behalf of the 13 companies in order to circumvent the scheme, which prescribed a ceiling of 1% on behalf of each non-resident of Indian nationality or origin, for each company 60% of whose shares were owned by non-residents of Indian origin and Indian nationality / origin. Our attention was drawn to the picturesque pronunciation of Lord Danny Kumar in Waller's versus Moyer and the decision of Tata Engineering and Locomotive and Company versus State of Bihar such and such. I'll skip to the third line. Was decided, has your lordship got it? Was decided that a company has an independent and legal personality. The third line. Was decided that the company has an independent and legal personality distinct from the individuals who are its members. It has since been held that the corporate will may be lifted, the corporate personality may be ignored, and the individual members recognized for who they are in certain exceptional circumstances. I'll not trouble your lordship much, but the law is well settled since 1897 that a company is a distinct and legal entity and it cannot be identified with the persons. Why I have referred to this judgment is only for the reason is that in their document, the Pattada's names are still there, and those who are deceased, in fact, they are legal heirs. We don't know who they are legal heirs. They may have 3-4 sons and daughters, their wives, their brothers, who had a right over this property. They were not the legal heirs. Directors can be anybody. Now the directors comes who are not the owners of the property. They come and they file this suit. So in my respectful submission before your lordship, this suit is not maintainable itself by them. Moreover, your lordship, and the next para thereafter, moreover, moreover, there is no pleading or exhibited revenue record to show that the suit land has been transferred by the Pattadas to the company, that is Gopal Krishna Tea Limited Private Limited. Under the opposite circumstances, when the land is not in the name of the company, that is Gopal Krishna Tea Company Private Limited, in revenue records and or no deed or conveyance of the suit land in favor of plaintiff company has been exhibited, then the plaintiff company Gopal Krishna Tea Company Limited cannot claim right title in interest of the suit land in absence of any title document in their possession. Now, number 2, your lordship, as per their own pleadings in the paragraph of the claim, the area of the land in dark number 3 of redeemed grant patta number 1 of village number 1, Neli Bagita Kisan Moza, the total area of land in the dark is 12 bigger 4 kata 12 acres. I have segregated it for your lordship. Page 11, your lordship has got it. Total area is 12 bigger 4 kata 12 acres. No boundary mentioned. They have not said any boundary regarding those particular plot of land. Then, number 2, less went to royalties 2 kata, 2 bigger 3 kata 10 lectures. Which portion of 2 bigger 3 kata 10 lectures went to the royalties? That boundary is also not been mentioned. The schedule has not been mentioned. Now the balance land, the suit land is 9 bigger 3 kata 8 lectures. The biggest contradiction is with respect to this. It is an admitted fact that 19 defendants are occupying those lands. Everybody's land cannot be a same schedule. It has to be different schedule because they are not from the same members of the family. It is not one family, it is 19 different families. Your lordship. So these 19 different families will have 19 different schedule in this 9 bighas land. So where is that schedule? You have not mentioned that schedule. Am I clear, your lordship? Could I make your lordship clear? There are 19 families. They have filed the case against 19 families for eviction. Now this 19 families. So this 19 different families will have different 19 schedules. So which are these schedules? So which part of the cake they are seeking? They have not stated so. And they have itself stated in their cross as well as evidence that they don't know the schedule. So what they are claiming if they don't know the schedule? I'll go through them, your lordship. Now, a balance land after deducting the suit is 2 kata 14 lectures. So, no pleadings in respect of this 2 kata 14 lectures. And and your lordship is well aware of the fact that the plaintiff has to prove his case. Here, the plaintiff miserably failed to show that this land belongs to them. So therefore, I have made this chart for the convenience of the court to show that they have miserably failed to say something about balance 2 kata 14 lectures and the boundary of the 9 bighas 3 kata 8 lectures. Now, if your lordships kindly take up the judgment passed by the Honorable Trial Court, issue number 4. Last paragraph, I'll not trouble your lordship with the entire para. My respected senior has gone through it. In internal page 10. Has your lordship got? From having perused the evidence on record, it appears to me that PW1, the plaintiff, having known all the facts, he has instituted the suit against the defendant since the PW1 has proved the certified copy of the Jamabandi of the suit matter, wherein it appears to me that the land measuring 3 biga 1 kata 4 ledgers out of 12 biga 4 kata 12 ledgers has been created as separate dag number 42. In compliance to the order of the SDO Morigao by Assistant Settlement Officer White, order dated 14/12/1977, and also acquired a land measuring 2 biga 3 kata 10 ledgers of dag number 3 as ceiling surplus land in the year 1971. I'll pause here for a moment. Has this orders passed by the Assistant Settlement Officer has been put to challenge? No. There is no challenge to these orders. Moreover, the plaintiff has not mentioned the description of the boundary of the suit land as illegally disposed by the defendant numbers 1 to 9. The plaintiff has also given common boundary of the suit land. The PW1 also does not know regarding the boundary of the occupier, and accordingly, I am of the view that the plaintiff is not entitled to get a decree for recovery of the khas possession of Schedule A land, and as such, the issue is decided against the plaintiff. Now your lordship will kindly come to the cross-examination of Pramod Kumar Jalan, that is PW1, at page 40.
Yes.
This is PW1, Pramod Kumar Jalan, cross. I cannot say the boundary of the residence of the defendant numbers 1 to 19. A Rayati Khatian was issued on 25/5/1982 for a plot of land measuring such and such. I cannot say whether the Rayati Khatian was issued or not in respect of 1 biga 1 kata land in favor of Thanugwala. Gopal Krishna Tea Estate was established in the year 1960 to 63. At that time, the same was a partnership firm. In the year 1960 to 63, my father has purchased the entire tea estate. I have no claim regarding the issuance of the Rayati Khatan such and such. I cannot say that the land measuring 105 bigas of Gopal Krishna tea estates were declared selling surplus land on 18/10/77, since at that time my father was alive. I'll pause there for a moment. Nothing is in his knowledge. He could have easily gathered from this from the settlement officer. I would say he was lying on teeth. True state. It is not a fact that defendant numbers 1 to 18 have been living in the selling surplus land since 1998. The defendant numbers 20 to 23, Pradeep Sarath, Prakash Chandra Dasani, Sahitya Narayan Daskarnani, were shareholders of my company. But he has not stated that they are the legal heirs of all the deceased persons who are the original pattadars of the land. If that be the case, how can he file a case, Your Lordship? My father expired on 20th August 2004. It is not a fact that my father was financially helped the defendant number 3, Bapu Sham, to construct a temple in our state. It is not a fact that defendant number 19, namely Bapu Sham, has been possessing the land of Raitan. It is not a fact that I have instituted the suit to harass the defendant. Now, Your Lordship, in the suit, they have categorically stated that this land has been in para 6, page 30. It is their own statement.
Paragraph 6, page number.
30, 3030 of the plaint. The plaint to 30 number page না ইন্টারনেট পেজ কই লাভ না সব মার্কিং করে দিয়ে যেহেতু উনি হইছে
Paragraph কি মান?
প্যারাগ্রাফ 6 স্যার
Yes.
that the Gopal Krishna Tea Company Private Limited has vast area of tea garden in Nelly area, and without the knowledge of the plaintiff's company, the principal defendants have constructed some temporary house in various portions of the suit land, and they have been residing thereon with their family members since 2 years, and has also been going to construct a small pakka house in one portion of the suit land for the purpose of assembling the principal defendant, as they are the followers of Satsang Bihar. I'll pause there for a moment, your lordship. First of all, they does not know what is the area of the Gopal Krishna Tea Company Private Limited. How much area of land does it have?
You are reading paragraph number 2.
6, your lordship. I'm sorry. Para 6, page 30.
Okay.
I'll read once again. That the Gopal Krishna Tea Company Private Limited has vast area of tea garden in the Nelly area, and without the knowledge of the plaintiff's company, the principal defendants have constructed some temporary houses in various portions of the suit land, and they have been residing thereon with their family members since 2 years, and has also been going to construct a small pakka house in one portion of the suit land for the purpose of assembling the principal defendants, as they are the followers of Satsang Bihar. Your lordship, they are not aware of the total area of the Gopal Krishna Tea Company Limited first. Secondly, they are alleging that a Satsang Bihar, some construction has been made for Satsang Bihar. Has Satsang Bihar been made arrayed as a party respondent or a defendant? No. So this suit is liable to be, should have been dismissed for non-joinder of necessary parties. No, I will know. Your lordship, I'll come to paragraph 2, but before that, I'll just read the with evidence of DW2, who happens to be the manager of the estate, at page 46. Page 46. PW2.
Yes.
I'll read from his Moisri Biren Doctor. He is the manager of the tea garden. I'll read from second para. Moi a gusor badi aru bibadikari sini pao aru gusoria mati sini pao. The next page. Moi Gopal Krishna Sa Bagisar 2007 চনৰ পৰা সহকাৰী মেনেজাৰ হিচাপে চাকৰি কৰি আছো আৰু গোপাল কৃষ্ণ চাহ বাগিচা অন্তৰ্ভুক্ত মাটি মই চোৱা চিতা কৰি আছো। গুচৰীয়া পদত চাহ বাগিচা 5 বিঘা 3 কঠা 15 লেচা মাটি কাটি কৰি নাম ভৰ্তি কৰা কি আছিলে কি নাম ভৰ্তি কৰি ৰাখিছে। গুচৰীয়া দাগ নম্বৰ 2, 3 নম্বৰ কালি হ'ল 9 বিঘা 3 কঠা 8 লেচা কিষাণ এক নেলি বাগিচা কিষাণ আৰু ইয়াৰ পাট্টা নম্বৰ 5 ৰিডিম গ্ৰান্ট গোপাল কৃষ্ণ চাহ বাগিচা পঞ্জীকৰণ চাহ বাগিচা আৰু পাট্টাদাৰ নম্বৰ অক্ষৰ জালান এই বাগিচাৰ সঞ্চালক আছিল আৰু তেওঁৰ 2004 চনত মৃত্যু হয়। তেওঁৰ মৃত্যুৰ পিছত তেওঁৰ পুতেক বাদী শ্ৰী প্ৰমোদ কুমাৰ জালান এই কোম্পানীৰ বৰ্তমান সঞ্চালক হিচাপে কাম কৰি আছে। I'll stop here for a moment. It is not stated that তেওঁৰ নাম উত্তৰাধিকাৰী হিচাপে এই মাটিটোত অন্তৰ্ভুক্ত কৰা হৈছে। He was only inducted as a director of the company. আন পাট্টাদাৰ সকলো ইতিমধ্যে মৃত্যু হৈছে আৰু সেইজন বৰ্তমান উত্তৰাধিকাৰী বৰ্তমান নেলি চাহ বাগিচাৰ মাটি উত্তৰাধিকাৰী অংশীদাৰ হৈ আছে আৰু জীয়াই থকা পাট্টাদাৰ অংশীদাৰ হৈ আছে। গোপাল কৃষ্ণ চাহ বাগিচা বৃহৎ অঞ্চল চাহ বাগিচা হিচাপে আছে পৃথক মূল বাদীৰ অবৈধ চাহ বাগিচাৰ গুচৰীয়া মাটিত কি আছে সোমাই বাদীৰ তেওঁলোকে অস্থায়ী ঘৰ সাজি পৰিয়াল লৈ বসবাস কৰি আছে। গোচৰ দিয়া অনুমানিক 2 বছৰ আগৰ পৰা আৰু তাতেই সৎসং বিহাৰ বুলি এক বহাগ ঘৰ সাজিছে। সৎসং বিহাৰ বুলি এক বহাঘৰ সাজিছে। So the manager himself admitted that Satsang Vihar has constructed there, but Satsang Vihar has not been implemented or arrayed as a party, defendant and respondent both in the title suit and before, and no leave was sought in this appeal also. So therefore, this is liable to be dismissed for non-gender of necessary parties. Now your lordship will kindly come to page 27, paragraph 2 of the plaint.
Page 27.
Of the 27 and paragraph 2 of the plaint. Internal page 4. Has your lordship got it?
Yes.
Paragraph number 2, that the suit redeem grant patta number 1 of village number 1 Neli Bagiza Kisam under Moja Uttar Khula in the district of Morigao, Assam previously was patta number 1 and dag number 3, and the area 9 bigas 3 katha 8 lechas previously was 12 bigas 4 kathas 12 lechas, out of which 2 bigas 3 katha 10 lechas has been included and Rayati Khatian by an order dated such and such as per Rayati Khatian Act by the Revenue Authority. It is their own admission, your lordship. Just at when my respected senior was making a submission that where is that Rayati Act, where that land has gone. It is their own admission in the suit that the land has gone under the Rayati Act. So you cannot approve it and reprove it at the same time. It is your own case. আৰু কি কৰিম এতিয়া? It is an admitted. Lordship, Exhibit Go, which categorically states, I'll not go through this. Exhibit Go is the document which was proved before the Honorable Trial Court also, wherein it was stated that Lasso Bhatra and Thanu Gwala, from their own share of land, has donated a portion of the land for construction of Satsang Vihar and for the other purpose to be carried out by them. It is their own admission. In spite of knowing that, they have not taken the leave of the Honorable Trial Court to array as a party respondent to the Satsang Vihar. In spite of that document having proved, dear Lordship. So I have nothing more
What
to
is
say.
Exhibit Go?
Exhibit Go is the NOC. It is at page 50.
But he can give a NOC in respect of the land which belongs to him. He cannot give the NOC in respect of the land belongs to others.
No. Whatever land was in their possession, they have given in respect of that land. It is not that they have given the land in respect of others, which they could not have given. And this was considered by the trial. That they have given whatever land was in their possession. They have given from that land. It is not that they have given some from some other land.
There also boundary has not been described.
Yes, Your Lordship.
In this exhibit Go also, the boundary has not been described.
Yes, Your Lordship. But they have given whatever land they have in that, they have given it to that.
Okay, any other point?
Two issues of law, my briefing counsel will.
My lord, one issue of law. My lord, whether right title interest can be claimed by a registered company for land belonging to the directors or shareholders of company. I repeat, my lord, whether right title interest can be claimed by a registered company belonging to, for land belonging to individual directors or shareholders of the company. Suppose we consider them to be the partners to be the shareholders.
Yes.
My lord, another thing, this is something whether granting of right title interest to the company for land belonging to the shareholders would tantamount to losing revenue by the state.
Pardon?
Whether granting of right title and interest to the company of the land belonging to the shareholders would tantamount to losing of revenue by the state. Because if right title interest is given for the land belonging to the shareholders, then transfer is not required. How the state would get revenue?
No, that is not the issue. It is
Because
Well, they are going
we
beyond the
have
pleadings, my lord. They are going beyond the pleadings.
Hmm.
I shall.
This is law point. My lord, another one. Now, my lord, section 91 and 92 of Indian Evidence Act. So this is law points, and I'm not going pleadings. 91 says that for disposition of property, it has to be proved by the document. and not by any other evidence, oral evidence. Section 91 and 92 says where it is to be proved by a document, then all other evidence would get expunged. So in this, my lord, whether the exhibit 2, that is the Jamabandi, is proving the title of the plaintiff under section 91 of Indian Evidence Act. That's it.
My lord. I have to, my lord, go to the this now, because what they have pleaded, what we have pleaded. Your losses may come to paragraph 3 of the plain, my lord. See,
Yes,
that one Askaran Jalan, son of so and so, so and so, so and so.
paragraph number,
Paragraph 3, page, internet page 6.
okay. Yes,
Manaskaran Jalan, son of Mahadev Jalan, Lokinayan Jalan, son of so and so, Bihailal Dasani, son of so and so, Sri Satyanaran Karlani, so and Srimati Nayani Devi, wife of late Mahadev Prasad Jalan, were the original pattadas of the Sur Patta village number so and so, so and so. Now, Gopal Kishore Tea Company Private Limited is a registered company bearing registration number so and so. The pattada Askaran Jalan, son of Mahadev Jalan, was the director of the company who died on so and so, leaving behind his son Sri Pramod Kumar Jalan, the plaintiff as the legal heir, and who after death of the father has been working as the director of the company. Pattada number 2, Lakhinayan Saraf, son of Chunilal Saraf, and shareholder of the company who died about 20 years ago, leaving behind his son, Sri Pradip Kumar Saraf, and who after the death of the father also has been remaining as shareholder of the company. The pattada number 3, Bahalal Dasani, son of Sri Tullar Dasani, was the director of the company who died about 3 years ago, leaving behind his legal heir, Sri Prakash Chandra Dasani, who after the death of his father has been working as director of the company. Pattada number 4, Sri Satyanan Kalani, son of so and so, has been working as director of the company. And pattada number 5, Nayani Devi, who wife of that Madhav Jalan shareholder of company, who died about 30 years back. The Pramod Jalan is a son. Lego, Askaran Jalan, who also died on so and so, leaving behind his legal heir Pramod Kumar Jalan, plaintiff, and also remaining shareholders, grandmothers of the company. After the death of the above mentioned pattadas, legal heirs of this pattadar, director shareholder as well as surviving pattadar, has been peacefully conducting the business of tea production and manufacturing of tea of Gopal Kishore Tea Company Private Limited situated at village so and so. This is Morigao through various workers, managers, and other employees of the company so and so. My lord, now I shall come to another. My lord, if your lords will see what they have pleaded, your lords may see the written statement filed by them. 118. My learned friend is appealing for Thanu Gwala, no? Thanu Gwala. But Thanu Gwala is not a party person. Thanu Gwala is not a party person. He appeared as a witness on behalf of defendant number 19 only. He is not a party person. Huh? No, maybe you are appealing for Thanu Gwala.
I'm preparing for 5.
Defendant 5. But you have said for Thanu Gwala.
Son of Thanu.
No, sir. Thanu Gwala has appeared as a witness on behalf of defendant number 19. Now, if you'll also see the written statement on behalf of defendant number 1 to 18, my lord. You'll also got it? My lord, the story in para 1 and 2 of future on, the contents of para 3 are matters of record of district revenue, so and so. Contents of para 6 and 9. My lord, 4, 5, they have not said anything, my lord. How they can argue it now, my lord? There is no pleadings and no issue has been framed in this regard. And they are, well, virtually now we have exhibited the revenue receipt. They are paying the land revenue in the Gopal Krishna Tea State, tea company. If you also see the revenue receipt, well, that is in the manager Gopal Krishna. And moreover, all the partners at the Matadans were arranged a party, my lord. I have in I have said, my lord, 2021, all. 9 will be, my lord, I am the, my lord, the Pramod Jalan is the son, so nobody is there. So everybody is a party, my lord. Nobody is opposed to this, my lord. Because they are the shareholders and the business is conducted in the name of Gopal Krishna Tea Estate. And they are paying the land revenue, my lord, in the Gopal Krishna Tea Estate name. And no bleeding so there, my lord. There is no occasion, my lord, to moreover, my lord. Exhibit Go, my learned friend is relying on. I have already said, my lord, this was by Thanu Gwala and another person. They said, my lord, dag number 2, they have gifted land. 4 bigha, 2 bigha by Thanu Gwala, 2 bigha by another person. And 1 katha of dag number 3 for road. 1 katha, my lord, I have nothing to say, my lord. 3 bigha, 1 katha, Odisha has been acquired by the under the Stealing Act of 1971. In 71, my lord. And for that, my lord, Raiti Khatian has been issued. My lord, although my lord, it was wrongly registered as Raiti Act, my lord, Raiti Act is not there. No, Raiti Act is existing, my lord, in the state of Assam. The excess land which has been taken, that Raiti Khatian has been issued by the government. I have nothing to say. So, exhibit, my lord, so Anu Goala has the Raiti Khatian in respect of dag number 2 mainly. And this another person, Jamuna Bhatta, he also in respect of dag number 2. So if they have any construction of our dag number 2, I have nothing to say, my lord. I am only in respect of, I have given the boundary of the 9 bigha and odd, my lord, land. And the director may not know, my lord, everything, my lord. That is nothing to say. But we have given it in the plaint, my lord, that the boundary of the land.
Okay.
Just one line I'll point it out, page number 37, in the written argument to what my respected senior has said, I have taken the plea that he has no locus standi to file the case. That plea was taken, and that was one of the contentions before the honorable trial court to decide the issue, and it was decided against him. Secondly, the honorable trial court has come to a conclusion on the documents perused that PW1 has been paying the land revenue for the year 2009-10, not prior to that. So only to make out a case, he did so. He paid the land revenue for the land in the year 2011 for the year 2009 and 10. That is admitted while the issue number 4 was decided. And that was very much there, your lordship. And he has himself said that the director is coming. Let him show that the legal heirs have come before this honorable court or before the trial court. They have approached the court. No. In fact, from the document itself, they have not been implemented. They have not been the legal heir.
Yes,
of the
all are implemented, my lord.
Anybody can be director, your lordship.
20, 21,
Anybody
22,
can be the
and
director of the
plaintiff, my lord,
company.
Pramod Jalan is very much there, my lord.
There
Pramod
can
Jalan
be a
is
shell
there.
company. Anybody can come and be a member of the director of the shell company.
Okay.
So this judgment does not call for interference, and this appeal is liable to be defended. I'm deeply obliged.
Heard Mr. G. N. Sayola, Lord Executive Counsel assisted by Ms. Johnson, Lord Advocate for the appellant. And Mr. Your good name, please.
R. Sinha.
R. Sena, Lord Advocate for the respondent. Argument concluded. Judgment reserved.
Timing item number 5. Number 5.
Question number 5. The council is supposed to come, but is absent. Wait for some time.
May I place your lordship?
Yes.
My lord, on the date of admitting this appeal, lordship, on 22nd May 2015, lordship, this honorable court was passed an order. Appellant shall be at liberty to raise any other substantial question of law at the time of hearing. Already, lordship, two substantial questions of law were formulated in this case, lordship. My humble submission, lordship, two other substantial question of law is required to be formulated in this case, lordship. In this case, lordship, in the title suit, lordship, the respondent had filed counterclaim, lordship. In that counterclaim, lordship, there was no prayer for declaration of right title interest. And no issue was also framed regarding that, lordship. But at the time of passing the judgment, lordship, the learned trial court declared title interest of the counterclaimant, lordship. That is another, that is
No, this
one.
suggested third substantial question of law is already incorporated in substantial question number 2.
That is with respect to recovery of possession, lordship. That is with respect to recovery of possession, lordship.
In dictating the counterclaim for eviction of the plaintiff from the suit.
Yes, lordship. They sought only for eviction, lordship, not declaration of right title interest, lordship. But right title interest, declaration of right title interest was granted, lordship. And another is, lordship, the plaintiff, the appellant as plaintiff, lordship, in his plaint, prayed for declaration of right title interest over the suit land, lordship. But no issue was framed with respect to the declaration of right title interest of plaintiff in the plain, lordship. So my humble request, lordship.
So have you furnished a copy to
Yes,
Mr. Tega?
I have furnished a copy.
So is there any necessity in framing?
Declaration of right title interest there was not made. Already it is made incorporated in the earlier the time of admission made. It is there whether the learned court below committed error in deciding title of the defendant number 6 and 7 over the whole plot of land.
That is another aspect, lordship. Two schedules are there. Schedule A is 3 kotha, lordship, and schedule B is 15 lesser. That is another law point was formulated, lordship, as because they sought only declaration of the learned court declared only B schedule land, lordship, not total A schedule land, whereas B schedule land is a part of the A schedule land, lordship. That is another question of law, lordship. But here, that my
Let us do one thing. You please go through it. We'll take it up on Thursday.
Yes.
Thursday. In the meantime, you go through.
Yes, ma'am. That will be better.
Thursday, Lordship.
For hearing on framing of additional substantial question. On
Lordship,
Thursday.
as Lordship stated regarding issue number already formulated number one issue, Lordship.
Mm.
So I have to go through also it whether that substantial question of law covers my additional substantial
Okay, you
question.
go through it.
I need some more time, Lordship. If
More time.
More time.
Okay.
After view vacation, Lordship.
No, it will be long day. Within
In the 2015.
yes, my lord. It is several times. It is
At least
my lord.
first week of April, Lordship. First week of April.
First week of April. Okay. As agreed by learned advocates of both the parties, recital list the matter on
3rd of April.
Huh?
3rd of April.
3rd of April. So as to enable the learned counsel for both the parties to examine the issue of framing additional substantial question of law as suggested by Mr. Sharma, learned counsel for the appellant, list accordingly.
Highly obliged.
Probably, my lord, it may be kept as a part that matter.
Okay, recital list the matter as part.
Matter number 8.
May I please, Your Lordship?
Mm.
This is a first appeal, Lordship. This is
Mm.
a first appeal against the order dated 13/6/2018.
Mm.
Against the judgment and order dated 13/6/2018. Lordship, impugn order is page 10, Lordship.
Mm.
And final order is page, Lordship, 16. In the memo of appeal, Lordship.
Page number
16, Lordship. This is a final order. The suit is decreed on contest with cause. The defendant is directed to execute the registered final sale deed for the suit land as described in the civil property of the plaintiff on receipt of balance payment of rupees 32 lakhs within 60 days from today, or in alternative, if the defendant refuses to execute the sale deed, the same shall executed by this court on behalf of the defendant, and thereafter the defendant shall hand over vacant possession of the suit land measuring 1/12.5 acres to the plaintiff. Prepare decree accordingly. This and Lordship, brief of the case is that in case 11, Lordship, in the impugn order, judgment and order, Lordship.
So it was a suit for specific purpose.
Specific performance, Lordship, suit for a decree of specific performance of contract dated 14/8/2013 by executing the registered sale deed in favor of the plaintiff after receipt of balance consideration of rupees 32 lakhs along with recovery of possession with other reliefs and cost of the suit. And there was issue was framed. There are 5 issues framed. Number 1, whether the suit is maintainable in law as well as on fact, whether the suit is barred by law of limitation, whether the plaintiff has been ready and willing to perform her part of the deed of agreement dated 14/8/2013, whether the plaintiff failed to perform the duty cast upon her by clause 1 of the said deed of agreement, whether the plaintiff is entitled to any relief as paid for. So issue number 1 in favor of the plaintiff, here is that the defendant has taken a plea that the suit is not maintainable in present form, but there is no specific averment to show why the suit is not maintainable.
Mm.
A casual averment made in written statement is not enough, and defendant has to impress upon the court to show as to why the suit of the plaintiff is not maintainable in its present form. And in absence of any such proof of specific pleading, this court cannot come to a definite conclusion. Moreover, the facts disclosed in the plain as well as the documents produced by the plaintiff in support of contention prima facie goes to show that the suit is maintainable and the plaintiff has paid required court fee and this court has jurisdiction to try the case. Hence, this suit is maintainable. This issue decided in favor of the plaintiff. Issue number 2, the defendant has taken a plea in written statement that suit is barred by limitation. Now, from the perusal of case record, it appears that the suit was instituted on 1/7/14. The agreement for sale between the parties in respect of the suit land was entered into on 4/8/2013. Hence, the suit is filed within the period of limitation. The issue is decided in favor of the plaintiff. Issue number 3 and 4. As both these issues are correlated, I propose to decide them together for the sake of convenience and brevity. Exhibit 1 is the agreement for sale dated 14/8/13 entered into between the parties, by which the defendant intended to sell the plot of land measuring 4.38 are covered by dark number 214 and KP Pata number 446, a total consideration of rupees 73 lakhs. Clause 1 of the agreement indicates that the plaintiff had paid an advance amount of rupees 38 lakhs on the date of agreement, and another rupees 3 lakhs was already paid prior to the agreement, which was duly received by the defendant. It was agreed that the balance amount of rupees 32 lakhs would be paid by the plaintiff at the time of final registration of the sale deed by the defendant in favor of the plaintiff. Exhibit 5 is the permission dated 28/5/14 issued by Office of the Deputy Commissioner, Kamrup Metro, pertaining to the suit land. PW1 Srimati Meena Devi and PW2 Sri Navneet Kumar Jaswal in their evidence in affidavit have reiterated the contents stated in the plain. PW3 Sri Sivan Bosumata in his evidence in affidavit supported the case of the plaintiff by stating that parties entered into an agreement for sale dated 14/8/13 by which the suit land was proposed to be sold at a consideration of rupees 73 lakhs, out of which plaintiff paid an advance rupees 38 lakhs on the date of execution of agreement, and another rupees 3 lakhs was paid prior to the said agreement, and defendant obtained requisite sale permission from Deputy Commissioner, Kamrup Metro, and it was agreed that the entire sale transaction will be completed within 1 year from the date of agreement for sale, Exhibit 1. It is further deposed that the defendant did not submit the sale permission applicable before the GMDA even after request made by the plaintiff, and was trying to avoid the execution of the sale deed in favor of the plaintiff in respect of the suit land. DW1 Sri Mukunda Chandra Das, the defendant, in his evidence in affidavit, also reiterated the contents stated in his written statement. In his cross-examination, he admitted that Exhibit 1 was executed by him for sale of the land measuring 1 kotha 12.5 acres at a total consideration of rupees 73 lakhs, and he had received rupees 38 lakhs in advance on the date of execution of the agreement. It is also stated in the cross-examination that he did not sign the sale permission application for GMDA, which was submitted to him by the plaintiff along with the duly sworn affidavit dated 12/5/14. It is also categorically admitted in the cross-examination by DW1 that he did not sign the sale permission application of GMDA as he thought of returning the money back to the plaintiff. DW1 here in her cross-examination has clearly stated that she paid rupees 41 lakhs to the defendant. It is also admitted in cross-examination that after demarcation and measurement of the land, the area was found to be 1 kotha 16.5 acres. PW2 in the cross-examination stated in Exhibit 1, it is not mentioned as to who will obtain the sale permission from GMDA. From the scrutiny of the entire evidence on record, it appears that the parties entered into an agreement for sale measuring 4.38 R covered by dark number 214 of KP Patana 446 filed agreement dated 14/8/2013, and in pursuant to the said agreement, the plaintiff paid rupees 38 lakhs to the defendant on the date of execution of the agreement, and another 3 lakhs has already paid prior to the execution of the agreement. The contents of Exhibit 1 indicates that it was agreed upon the plaintiff shall be paid the balance amount of rupees 32 lakhs to the defendant at the time of final registration of the sale deed. Exhibit 2 indicates that the defendant is the owner of the land. Exhibit 4 is the money receipt issued by the defendant in favor of the plaintiff for an amount of rupees 48 lakhs, and Exhibit 5 is the sale permission dated 28/5/14 from the Office of the Additional Deputy Commissioner, Kamrup Metro. The evidence of the plaintiff is clear, cogent, and convincing, and defendant has failed to demolish the testimony of the plaintiff witness during the course of cross-examination. This effort, the signature of the parties on the documents are not denied or disputed during trial. In fact, DW1 in the cross-examination has categorically admitted that she did not sign the application form for obtaining the permission from GMDA. The evidence of the plaintiff witness PW, that is PW1, PW2, PW3 are corroborative with each other on material points and suffer from no infirmity. No, their testimony could be demolished or rebutted during their cross-examination. From a discrete perusal of the entire evidence on record, both oral and documentary, I see no cogent and justifiable reasons to disbelieve the case of the plaintiff, which has been corroborated by the evidence on materials point. In view of discussion that preceded above, it is clearly that the plaintiff has able to prove the case with clear, present, and corroborative evidence. Hence, issue number 3 is decided in positive in favor of the plaintiff, and issue number 4 is also decided negative in favor of the plaintiff. Issue number 5, in relevancy of the discussion made
Okay,
above,
all right. But what are the grounds?
grounds, Lordship, we have mentioned already, because Lordship, gone through the exhibit number 1 in the LCR, Lordship. This is a exhibit 1 is the
No, grounds for filing this appeal, you come to your memo of
yes, memo of appeal is the Lordship we have already mentioned. Mainly 8, paragraph, page number 14, Lordship.
mainly
8. 4.
page number
4. Memo of appeal.
and point number
Lordship, GNH, Lordship.
DNH.
Again. For the learned trial court below failed to appreciate the evidence of PW1 when the respondent as plaintiff herein is not ready to solve the dispute, which arose prior to file the suit after execution of the sale agreement for sale. Exhibit 1. It was agreed to that if ever any dispute whatsoever arises over the scheduled plot of land, the respondent herein shall solve it. Exhibit 1 therefore clearly goes to show that plaintiff was not ready and willing to abide by the terms and conditions of the agreement for sale. Exhibit 1 and the learned trial court below having failed to take note of the said aspect of the matter have rendered the impugned judgment and decrees bad in law and accordingly liable to be set aside and quashed. It for that perusal of the cross-examination of the respondent hearing, plaintiff witness number 1 would go to show that plaintiff witness number 1 had clearly admitted that in the event of accrual of any dispute in respect of the scheduled plot of land, it is the plaintiff who was to take care and solve the same, and she has also admitted that in clause number 9 of the exhibit 1 that there is a terms and condition that at the time of delivering the khas possession, if the area of the scheduled property increases or decreases after proper demarcation, then the value of the scheduled property will be mutually decided by the parties themselves, but which was not complied by the respondent with the appellant and failed to solve the dispute mutually. This is the ground in this case, Lordship. This is only ground. And
So this being the
this also raised in
regular
the
first
written
appeal.
statement also file in that
No,
ground was taken in the written statement also.
you say this being the regular first appeal,
Yeah.
we have to formulate the point for determination.
Yes.
So what would be the point for determination you suggested?
Lordship, a point of determination is that
No, you see both the side has to assist the court in framing the issue, framing the point.
Point of determination, may I appeal, Lordship, and for the determination of this appeal, tell me that whether the land trial court below has taken into note of evidences on record of both the parties in its true perspective.
Learned trial court
Have taken note of the evidences available on record of both the parties in its true perspective. On discussion of this particular issue, point for determination, your lordship may be in a position to decide the appeal in totality, my lord. So defendant, in his own evidence, your lordship, he has admitted clearly that he had failed to sign the application required to be submitted before the GMD for self-permission. This is the denial part of appellate.
In deciding all the issues or in deciding a particular issue?
My lord, colleague has emphasis much more on ground number H only, my lord.
Hmm.
That's why, my lord, I'm suggesting this point for determination. Because in the written, this is registered instrument, my lord. Agreement for sale is registered. Wherein there is no such clause that in case of dispute that shall be resolved amicably.
There is no dispute
No
that
such-
there is,
no such
it
clause,
is,
my lord. This agreement is
that's
silent to that effect. Regarding, my lord, enhancement of consideration amount that is to be decided at the time of execution of final sale deed. For that purpose, my lord, sale permission has not been obtained from the GMD. Only DC has granted sale permission, my lord. Due to lack of sale permission from the GMD, sale could not be completed. At the time of completion of sale process, the quantum of sale consideration shall be decided. And plaintiff respondent had never denied the same, my lord. Furthermore, my lord, this is admitted position of fact, my lord, land was never demarcated.
dispute was raised
Land was
because
never demarcated. So question of decrease or increase does not arise at all. Further, my lord, exhibit, my lord, 2, patta of the appellant, my lord. Exhibit 2 is patta. That is available in the record, my lord, of the file book. Exhibit 2,
The point is whether the learned trial court has taken note of the evidence that used by both the parties in its true perspective in deciding the issue.
my lord,
That is
my lord,
only one point for determination will do.
my lord.
and main the dispute is that about agreement in exhibit 1. Defendant has not complied plaintiff has not complied as per agreement number sub clause number 9. That aspects are not considered by the trial court because there is a surplus of 4 quarters of land. That amount was not ready to pay. This in cross examination also admitted by the PW1. That's as well not considered in the trial court. Because without after selling the 1 gotha 12.5 lesser, 4 lesser is valueless purchase.
To that effect, my lord, I am coming to exhibit 2 of the plaintiff. Lordship may cannot see in that file court, my lord. Exhibit 2 is the patta, final patta. Exhibit 2 contains land measuring, my lord. 4.38 R. Exhibit 2. Tax with evidence on affidavit of PW1. Evidence on affidavit of PW1, my lord, exhibit 2. Patta.
Evidence of PW1.
1 year, my lord. Who was the plaintiff respondent here in your lordship?
Yes.
Patta, your lordship cannot see the reverse side of this patta. Because, my lord, appellant had agreed to sell the land to the respondent, my lord, covered by that number 214 of keeping patta number 446, which contains, my lord, 4.38 R. Quantum of land has been mentioned in this patta, my lord. This is Jamamudi, my lord, prior to this. They give it to, my lord. Page 17, my lord. This evidence.
Page
17, my lord. What's it?
Seventeen, not yet. 17 or
17, my lord. This might have been dismantled, my lord, at the time of transmission of record. Preparation of tabular content. Even in one, I think.
page number 17?
My lord.
It is exhibit 2. Oh, it is not property part.
Lordship, can you allow me to access my lord?
Yes. Then what is this? Exhibit 2?
Exhibit 2 is the jump, final putta. Issued by the revenue authority. Its backside, my lord, contains the tag number, quantum of land, and putta number. This is the copy of putta, my lord. And my lord, at the reverse side of this putta, my lord. Putta number has been shown as 446, my lord. Dag number 214, containing land measuring 4.3 dar, which amounts to 2 kata 49. 12.5% roughly. How the vendor can sell the land measuring 2 kata 16.5 my lord? His title document shows he is having land in this particular dag because the vendor had not agreed to sell the land of other dag. Vendor had agreed to sell the land of dag number 214, which contains, my lord, land measuring 2 kata, 1 kata, 12.5 lesser, my lord. And this is also admitted position of fact, land was never demarcated. And clause number 9, which my lord, my colleague refers, clause number 9 of the agreement for sale may kindly be seen, my lord. This is exhibit number 1. Prior to this agreement, exhibit number 1, my lord. Internal page number 4. Clause number 9. He has been putting much emphasis on this particular clause of this registered agreement for sale. Clause number 9, that it, lordship got it? That it is hereby agreed by both the parties that at the time of delivering the cash position, if the area of scheduled property increases or decreases after property demarcation, then the value of the property will be mutually decided by the parties. Till now, land has neither been demarcated nor been position delivered. That's why plaintiff was compelled to file this suit seeking recovery position, my lord, in the plaint. A degree of recovery position has also been granted, my lord. Only after recovery position, if the land increases or decreases, then the value can be negotiated, my lord, which plaintiff never denied. But my lord, the applicant is having land measuring 2 kata, 1 kata, 12.5 lesser only, as per Jamabandi, my lord. He cannot go for sale over the land measuring 1 kata, 16.5 lesser, my lord, demanding money for the same. Till that, there is no demand from the side of the applicant that you have to pay more money for this excess 4 lesser assortment. No such communication has been made, my. And my lord, judgment clearly showed during cross-examination, nothing could be contradicted by the appellant before the trial court, my lord. Only one sentence, my lord, I am placing before your lordship, cross-examination of DW1. Only one sentence is sufficient to degree my suit. Cross-examination DW1. This is the only witness for the defendant before the trial court, my lord.
Yes.
Cross-examination, page number 3, my lord. I'm not reading the all cross-examination. Only relevant portion I am reading, my lord. Page number 3, my lord. Last paragraph. Cross-examination, page number 3, last paragraph, my lord. Got it? Last paragraph. I have not signed the sale permission application of BMDF, which was submitted to me by Meena Devi, along with duly shown affidavit dated 12/6/14. But I have not signed the same with a view to return her money. But till date, I have not returned the money as plaintiff has not come forward to accept the same. There is no demand was made from the side of the appellant defendant to the plaintiff. You come forward and take back your money. No such demand has been made, my lord. I have not intimated in writing to the plaintiff, showing my intention to return her money. I don't know quantum of land shown in Exhibit 2 and 3. Exhibit 2 and 3, Jamabandi and final patta. These are the documents of the defendant, my lord, appellant. Next, my lord, third paragraph of page 4. In this case, I am the only DW and except myself, I don't have any other witnesses to be examined in this hearing. Last sentence, my lord. I have denied to sell the suit land to the plaintiff and not denied by the plaintiff to purchase the same as per Exhibit 1. Defendant denied to sell, plaintiff had not denied to purchase. So this is suit for specific performance, my lord. What more is required before the trial court for declaring the suit?
Yes, Mr. Bora?
My specific submission is that that surplus, because as per clause 9, it clearly indicate that any dispute raised, then it is that aspect was not considered by the trial court. Because I want to raise the in written statement, paragraph 9 also, it was stated that at the outset of the defendant likes to state that the plaintiff has suppressed the material fact that as the parties in the suit demarcated the property, come to know that the actual measurement of the property is 1 kotha 16 and half lesser, which is more than 1 kotha 12 and half lesser, as mentioned in the plan, as well as in the said deed of agreement. As per clause 9 of the deed of agreement dated 14/8/2013, registered as deed number 7061 before the sub-register at Guwahati, if the area of the civil property increases or decreases after proper demarcation, then the value of the civil property will mutually decided by the parties themselves. Per se, by suppressing aforesaid materials fact, the plaintiff is trying to misguide the honorable court. Hence, this suit is liable to be dismissed. Moreover, the plaintiff is not willing and ready to settle value of increased area in the civil property, which reveals that the plaintiff is not performing her part of contract. And now in cross part of the PW1, may I read? PW1.
So in the written statement, you have.
I have read from the written statement in paragraph
point
9.
number 9.
Paragraph 9. Okay. That plea was already taken, and it was not that observation was taken by the honorable trial court in this the judgment, and that is an error in the judgment, lordship, and in cross examination also, lordship. May I read PW1, lordship? PW on the second page, lordship, relevant portion. Third paragraph. The balance amount was to be paid after 1 month. I had applied for the permission to GMDA Guwahati. Everything for permission from GMDA was done from our side. there was an agreement with the defendant to the effect that permission would be obtained by us. We have received permission from GMDA. I agree to clause number 9 of the agreement, exhibit 1. I do not know if the length of the land is 82 feet and 60 feet wide. After demarcation and measurement, area of the land was found to be 1 kotha 16.5 lesser. She already admitted it. That aspect was not reflected in the judgment also. And this surplus of 4 lesser of land what was not decided as per agreement clause 9. Therefore, this judgment was error in the reflecting that aspect also. So plaintiff was not ready to perform their duty.
So whether any issue was framed on that
That basis was not a frame, Lordship.
willingness and readiness to perform their part of
Because this is also not frame in the trial court.
issue?
Yeah.
No, it was
As per
your
agreement,
duty
Lordship,
also
that
to
there is a
point it
specific
out.
clause that if there is any surplus or decrease or increase at the land,
That issue is there already, my lord, issue number 3.
Readiness and willingness. That is there.
Here, madam, issue number 3.
plaintiff is ready or not. That's
Issue number 3, my lord.
but
Whether
that aspect was not considered in
plaintiff
the
has been
trial
ready
court.
and willing to perform her part of work.
Okay.
But
Issue
regarding this dispute, that part
Issue
was
number
not
3.
considered.
Issue number 3.
3, my lord. And it covers, it also, subject matter also covered by issue number 4. Plaintiff had failed to perform her part, degree part, in terms of exhibit 1 or not. This is issue number 4, my lord. These two issues are very much essential, my lord, and faculty and trial court has decided. That's it.
But basis aspect was not considered by the trial court.
It's okay. I'm. Not the time, Lordship. Hello, Lordship, my learned colleague has been putting much emphasis on issue on clause number 9 of exhibit 1. So, Lordship, I cannot see clause number 9 in
Agreement.
agreement, my lord, exhibit 1. It is hereby agreed by both the parties that at the time of delivering the khas possession, if the area of civil property increases or decreases after proper demarcation, then the value of the civil property will be mutually decided by the parties themselves. My lord, time of delivery of possession has not come up. Property has not been delivered to the plaintiff, my lord. That's why, my lord, plaintiff has filed the suit for taking degree for recovery of possession also. Possession in terms of this clause is yet to be delivered to the plaintiff, my lord.
That agreement is
Exhibit 1, my lord.
exhibit 1.
1. Internal page number 4. Internal page number 4, my lord. Close number.
Page number.
Page number 4, close number 9. Internal page number 4, my lord.
Yes.
Close number 9.
Yes.
That it is hereby agreed by both the parties that at the time of delivering the khas possession, if the area of civil property increases or decreases after proper demarcation, then the value of the civil property will be mutually decided by both the parties. My lord, possession has not yet been delivered. Delivery is yet to take place. And my lord, for this purpose, recovery of possession has been sought for before the trial court, my lord, which has been decreed. Without delivering the possession, my lord, how the applicant can demand more money? This is one aspect, my lord. Second aspect, my lord, I have showed the title document of the applicant, my lord. He is having a land only 1 kata 12 and a half acres. How he can go for sale in respect of land measuring 1 kata 16 and a half acres, my lord? Thirdly, your lordship, exhibit, your lordship, may kind of to see exhibit 5, sale permission obtained by applicant himself from the office of the DC. Exhibit 5, my lord. Sale permission dated 28/5/14. Lordship got it?
Yeah.
Your lordship may kind of see the quantum of land permitted to transfer is 4.318 R, which amounts to 1 kata 12 and a half acres. He cannot demand much money, much more money. This is sale permission obtained by the appellant himself, by which appellant was permitted to say, go for sale in respect of land measuring 4.38 R, which amounts to 1 kata 12 and a half acres. By traveling beyond this permission, he cannot go for sale of 1 kata 16 acres of land. His patta, his Jamabandi, does not true that he is having land measuring 1 kata 16 acres in DAG number 214. So, my lord, as per his title document, he cannot demand much more money for excess 4 acres of land. If there is excess 4 acres of land, that's a limit in his possession and custody. He can neither sell nor I can purchase.
So the possession is yet to be delivered.
My lord, I have sought for degree for recovery of possession, my lord. That is to be decreed in my favor. That is to be executed after the execution of registered sale deed.
So Mr. Bora, as per this clause 9 of the agreement, it has to be at the time of
Delivery of possession.
delivery of
There is
possession.
not clearly mentioned that where the first position is given, but in that time they have tried to demarcate the scheduled land, and therefore it comes out that it's more than 2 lesser, 12 lesser, 1 kata 12 lesser and half.
Degree of delivery of possession is there, my lord, in the evening judgment. My lordship may cannot see. This is the order, final order, my lord. Thereafter, the first direction was given that the defendant is to may execute registered sale deed in favor of the plaintiff, and thereafter the defendant shall hand over vacant possession of the suit land measuring 1 kata 12 and a half acres to the plaintiff, my lord. This is the decree.
Yes.
If this is submission.
Any other point?
This is only dispute.
This is out of purview of dispute, my lord, with all respect and respect.
Pardon?
Out of purview of dispute. This demand of 4 lakhs money is out of purview of dispute, my lord.
The people are learning for the appellant and Mr. S.A.
And alam.
N. Alam, learning for the this one argument concluded, order reserved judgment.
Much more.
Timing, I don't know, 5.
I'm sorry, Lordship. But Mr. S.P. Chaudhary is not.
2011 matter, madam.
Yes, Lordship, Thursday. I'm ready to do. But
Thursday.
since Mr. Chaudhary is not there, let it come on Thursday, Lordship. And let it come as top of the list, Lordship. That is easier. Thursday is a hearing day.
No, Mr. Solri was there.
Yes,
earlier.
I am also in the court only, Lordship. This
Okay.
court, that court. They have.
Appear being made by Ms. Majumdar, learned counsel for the appellant, register makes the matter on Thursday, at top of the list.
Yes, Lordship. Highly obliged.
May I please, your lordship?
My lord, I seek your indulgence, my lord, to take the matter after Bihu vacation, my lord. Mr. Dory, elder brother, my lord, died. That is why he is on salvation, my lord. He will come before your lordship. Anyway, we will do the case, my lord, after vacation, my lord. Kindly date may be fixed. I have.
My lord, it is the, my lord, my client, my lord, is a bedridden. And since 2009, he is agitating and they are enjoying the operation of stay order.
If the letting council is absent, then what will happen?
That's why,
The
my lord.
lordship fixed the matter, my lord, before Bihu vacation.
My lord,
It is not that, my lord, lordship will the several dates, my lord, adjournment has been taken in the name of senior council. It does not mean that, my lord, if senior council is not there, they cannot do that.
any date, my lord, subject to your lordship convenience. Any date, we will do the.
Okay.
Before first week of April
No, no, before, not before first week of April.
or before Bihu vacation.
We will try before Bihu vacation.
My lord.
As agreed by learned advocate to both the parties,
My lord.
SSL list the matter on first of April. First April.
My lord, he will come from Delhi, my lord. I have taken his,
Acha.
and that's why, my lord, I am before you. Any date, my lord, after vacation. But he is on salvation, that's why.
Third, my lord. Third April. No, no,
22nd.
before vacation I need. Because
So
my lord,
vacation,
my client
expresses
may not
immunity.
survive also, my lord. He has the failure of cardio as well as the kidney. That's why I was insisting. And my lord, at my instance, I moved several petition, then only matter got listed.
My
I
lord,
told my learned brother also this morning
I-
to take it on.
I also, my lord, called my learned senior, my lord, for
Okay,
mentioning
you
matter.
discuss the matter and take a date from him.
Our lordship fix the matter on 3rd April, my lord. If does not come, then we'll see, my.
My
If
lord,
his senior does not come, my lord, I made a commitment. I'll not object.
my
Let
lord,
it be fixed on 3rd April.
Okay.
after verification, my lord, if I am not, he will not come, my lord, my case will go, my lord. My case will go, my lord. I am giving such type of decision before you.
3rd April, my.
Okay, we will extend
Yes, sir.
the event of your letting council remain absent on that day. We'll consider your pair on that day.
My lord. Oblige. your lordship.
Lordship. Permit Council representing NF Railway, Mr. V. Sharma, due to personal.
Oh.
Vijay Sharma, Lordship.
Oh.
Vijay Sharma,
Acha.
Learned Standing Council representing NF Railway, is not present today because of personal difficulties. The matter may come
This
after
is a
3
railway
weeks.
matter.
Lordship. Yes, Lordship.
Lordship, we are the appellant. We are the appellant. Their suit has been decreed. Suit against declaration of suit in respect of declaration of right title interest, recovery of possession, and for injunction. I was the defendant, sole defendant, and the government also made parties. So suit has been decreed in their favor. So there was a building. Lordship, we could not. I am a builder. We started construction. We purchased the land. So their claim is that it is their property was acquisition in the year 1958 in the name of railway, but land record was not corrected. So the original owners who sold out the land as per the revenue record, we purchased it. So Lordship, those landlords are not made parties. There is a matter of issue to be decided by the Honorable Court. So Lordship, the matters are because I, being a builder, I have made construction. I took money from the several purchasers, and the matter is pending. So Lordship, this 19 this appeal is pending. So early disposal is required. So that may I pray for 3rd of April, Lordship.
So we have lot of matters
Lordship, after vacation,
after vacation.
date may be fixed, your Lord.
Okay, suggest that after vacation.
After vacation. Vacation 22nd of Lordship,
April.
April.
Your good name, please?
Oh, Didas appearing on behalf of
Mr.
B. Sharma.
Didas, learned counsel appearing on behalf of Mr. B. Sharma.
Standing counsel.
Standing counsel for the
Railways.
railway.
NFA.
With consent from the other side, press for listening the matter on 22nd of April.
Lordship.
Okay.
Hello,
There-
hello, apply.
Okay, Madam Capcom for respondent number. Please press.
Apply.
This matters only relates to this quantum of alimony, my lord. This appellant in first occasion, and the RFA was filed, it's remanded back. Then again, my lord, the order is passed, and the 2 lakhs is given. So against that is came, my lord.
You are for?
I'm from the husband, my lord, a title divorce suit PSD was filed against this wife. This is respondent number 1, alleging that the wife has some extramarital relations with the respondent number 2. And on that occasion, my lord, this case is disposed of title suit with the order, my lord, page 33, that divorce is granted. So page 33 is the order, my lord. It is a background, my lord, that divorce is granted on that count, and only revision is.
So the matter was remanded.
That
earlier.
is the first, my lord, this order, 4 lakhs is given as alimony, agreed by that. To limited extent, first RFA was filed, that is page 38, annexure B. So here, this honorable court entertaining this petition, with opine that page 41, that a petition under section 25 of Hindu Marriage Act that was not filed. So reasonable opportunity was not given to the husband opposite party to react. So that is why it was remanded back with a direction to given the ample opportunity. My lord, this husband's is that the 25(3) of Hindu Marriage Act, a permanent alimony.
No, the dispute is regarding only the alimony.
Alimony, only limited purpose of quantum of alimony, nothing else. But that is the issue, my lord. And then, my lord.
So after remand, the trial court has decided the quantum at rupees
4 lakhs.
again.
No.
It was reduced to
2 lakhs.
2 lakh.
Yes, 2 lakhs. My lord, our ground is that.
So you are for the husband.
Yes, I am for
You are agree for awarding this 2 lakh.
2 lakhs, yes. Because this Honorable High Court in his judgment, its earlier RFA, says that ample opportunity should be given. But what happened when this remanded back in 19, 20 and 21, due to COVID, my lord, this petitioner, the appellant is the retired headmaster, 71 years of age, and his pension amount is not 50 lakhs, it is much less than that. And this claim that we have landed property, that was also not done. So this trial court has opined that page 78, that we could have give evidence, but nobody turned to give evidence. On that, the trial court has again decided that 2 lakhs is the reasonable amount.
On what basis trial court has decided?
That is basis is that just there is no evidence, without any evidence, because
You do one thing. You heard about the judgment? It's Neha versus the judgment.
yes, Neha versus my lord, and assets and liability should be determined, my lord, but both.
My lord,
That is.
So you file the assets and liabilities before this court. We'll see.
Or your lordship can remand back, then trial court simple issue that both the parties, that's be
I am
decided.
for the wife, my lord. And here the case is not that the trial court has done anything wrong, matter, because my lord, while the honorable court remanded the matter to the trial court, and the liberty was given him to represent that petition, my lord. Accordingly, we filed a petition under section 25 of the Hindu Marriage Act. Then, my lord, he appeared there and he filed his written statement also, but he did not file his evidence.
And because of that, ultimately the court decided on the basis of pleading of both the parties. Now, he has taken the ground that the trial court has not given him the opportunity to adduce his evidence in his ground matter. If Lordship comes to his ground matter,
Let it be there. But you file this, affidavit disclosing your assets and liabilities,
That also
both
can
the parties.
yes,
We'll decide the matter here.
yes,
Will
ma'am.
not remand the matter back to the
Yes,
trial
ma'am.
court.
Again and again, madam.
Otherwise, again, you will come.
Yes.
You or anyone may come. So let us finally hear and dispose of it.
Yes.
Yes.
So we'll fix it that in the meantime, both of you file the.
Yes, I will contact
affidavit.
this. Yes.
Affidavit. Third, Mr.
I'm Jaguru.
Hodwa, learned counsel for the appellant, and Mr.
PK Das, ma'am.
PK Das, learned counsel for the response. Having heard the submission of learned advocates of both the parties, it is provided that in view of the decision of Honorable Supreme Court in the case of Rajneesh versus Neha, reported in, I will give you later. Both the parties shall file their affidavit disclosing their assets and liabilities before this court on or before when before view vacation.
After view, my lord, I have to contact his interior place of Kampur, my lord. I send some message to that persons, then I have to arrange it, my lord. Just after view, any dates, my lord.
24th of April.
My lord, problem. The 2021 2 SCC 324 Rajesh versus
Rajneesh versus Neha.
yes, 2021 2 SCC 324. Oblige me.
My lord, in this matter, I am ready for hearing. My first, my learned friend.
My lord, Mr. Sapra was supposed to argue the matter, my senior, my lord. He was here in the court, but since he is fasting for Ramzan, my lord, he was not feeling well. So he has asked me to make a prayer before this honorable court to have the matter after the vacation, my lord.
After view vacation.
My lord, any date, my lord, as your
my
lordship
submission is-
fixes, as
my
per
submission
the,
is, my lord.
as allowed by the business of this honorable court.
My lord, my problem is that the present, my lord, I'm the defendant plaintiff, plaintiff respondent, my lord. I'm the 83 years old, my lord, with the 2004 suit, my lord, and my lord, been seeking time. I'm not objecting, but any date, my lord, after Eid festivals, my lord. That is my prayer, my lord. Can it be on 8th of April, my lord, before view? That is my humble prayer, my lord. 8th of April.
Yes.
My lord, the instruction,
April.
the
My
instruction
team-
I got from my senior, my lord, to make the prayer
of
after,
April will
after the
try around.
vacation, my lord, because the
No,
first
my lord,
week,
no,
will-
before view vacation,
the
is too
first
late, my
week
lord.
will,
8th of
That's all right. After Eid, after
Eid, yes, my lord.
my lord, the thing is that he'll be
Against
going to his
concurrent
native
findings, my
place.
lord. This is
He'll be
April.
going to his native place, and it will be a bit hectic, my lord. So the prayer was made like, my lord, after the
8th of April, my lord. Kindly, this is my prayer may be considered, my lord.
Your lordship fixes thereafter.
8th of April, my
Because
prayer may be
we have never sought for adjournment in the for hearing, my lord.
No,
at
that's
this
all
time.
right. 8th of April, would it
8th of
be
April.
inconvenient to you?
My lord, he told me that he'll just return, my lord. It'll be too hectic for him.
Then 10th of April, my lord. Then 10th of April, Thursday, my lord. Kindly,
Okay.
my lord.
Okay. As acted by learned advocates of both the parties, as shall raise the matter on 10th of April.
Deep, lord.
10th of-
We'll make an attempt.
Deep, lord.
Number 16.
We will again pray for time, Lord. Lordship, my senior is a code number 19, Lordship. Our hearing is going on, so that's why he is not here, Lordship.
Who is your senior?
Mr. A.M. Borguia.
Difficulty is that, Lordship, the petitioner is 26 years old at that Lordship, and only 2 lakhs of rupees has been given to her as permanent advance. Which was done. The problem is that 2 lakhs of rupees. Entire life she has entire life of it. And they are enjoying stay and taking time off.
Matter will be taken on Thursday, Lordship.
Thursday. Yes, madam.
Yes, Lord. I
Thursday. Okay. On the prayer being made by Miss A. Begum, learned counsel, appearing on behalf of Mr. A. Forward, learned counsel for the appellant. Registrar shall list the matter on Thursday.
Lordship.
It is provided that no further adjournment will be granted to
Earlier
the
intim-
council for that.
earlier intimation may be continued, Lordship.
Any other? Over.
Council, he was there, I was not there.
On Thursday, I think.
It isn't fixed on Thursday, no?
It's top of the list item.
Top of the